Back on the record. Good morning, everyone. We are here in the evidentiary hearing for case number 9490, the Potomac Edison rate case hearing. Do we have any preliminary matters this morning before we get started?
Yes, Your Honor.
Mr. Cleaver?
Yes, thank you, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel. Your Honor, as you know, OPC reserved the right to object to the motion that the company made on Tuesday in response to my partial version of 40-15, the staff response. And then I renewed that yesterday, same request for a reservation with respect to what was marked as Staff Exhibit 2, the company's response to Staff DR 4015. And our request to reserve the right to object was based on the fact that there were these outstanding discovery responses. So we received those last night, and they reveal that the number, or at least one of the numbers, as set forth in the revenue requirement schedules has changed again. They also reveal that there was an error in Exhibit LMO1, which was part of Staff Exhibit 2, which is the Ms. O'Black's exhibit incorporating the revenue requirement changes. So at this time, we would object to the introduction of what's been marked as Staff Exhibit 2 because it's not correct. It's been changed. It's no longer the correct revenue requirement in the case. It also included in Staff Exhibit 2 was LMO1, which is also, I think there's an error in that. Substantively, we don't oppose the company updating and correcting Exhibit JLA 21 and Exhibit LMO1, the two exhibits attached to what's been marked as Staff Exhibit 2, and putting those into the record. We don't object to that. Now that we've had a chance to understand the changes that have occurred. So if the company were to put that in the record, we would not object to that. But we'd object to 2 at this point on the basis that it's not correct. And we would also ask to have marked and move into evidence the company's responses to OPC DR Set 31 that were produced last night that explain these changes. Even though Mr. Adams' testimony has come and gone, and he's not here to do the typical, you sponsored these and to authenticate them and to put them in like that.
Okay. So we have two issues. You're asking for the admission. Are you asking? We don't have that in front of us.
Yes, I have it here, and I could approach and pass it out for the commission to review.
We'll hold off on that until I hear the company's response. But so we have the issue as to whether you believe that that Staff Exhibit 2 has some errors in it. Does the company have a response?
Yes, the company does. You have 2 documents, one that the staff has offered into evidence and one that apparently OPC plans to offer into evidence. They are formatted differently. They are responsive to different questions. They contain different information. There's a lot more information in the staff document than there is in the document that apparently OPC wants to offer, and that's a function of their responses to different, there being responses to different questions. It is correct that there is, I believe it is correct, that there is one correction of data and one update of data in the document that OPC is now offering. So with those two changes would inform the Commission's understanding of 2 parts of the larger and different document that staff wants to offer. So it seems to me, both for the purpose of the Commission's understanding and for the completeness of the record, and to fit into the fact that questions have already been asked about the document that staff has marked and offered, that the proper solution would be to admit both documents And the commission would probably, when they looked at one, would want to have the other with them because one has more information, the other has one correction and one update. So you'd want both. And that would be the company's proposal. We continue to not object to in fact, we now affirmatively support the admission of the staff document. The staff document, it turns out, while it has more of the response to 4015, still apparently was missing a few pages. So we brought with us today a absolutely complete version of it that could be substituted. I believe staff's agreeable to that. And we do not object if OPC offers the most recent data request response with the differently formatted and in 2 instances different data and otherwise less complete and voluminous data than is in the staff document. If OPC wants that in the record too, the company does not object. So that's our position. Put them both in.
I'm trying to make sure I understand that
Sure.
these two are tied together, that the staff exhibit 2, you agree has some errors and requires an update or has an update in it.
The 2 documents are different because they answer different questions. There's more information, substantially more information, in the staff document than in the document that OPC intends to offer. They nonetheless overlap. And at 2 points where they overlap, one there is a correction and one there is an update.
Okay.
Those are the facts as I understand them. And to my mind, the most efficient way and the most transparent way to get all the information to the commission so the commission can see everything is to put both documents in, and then you will want, when you look at the staff document, to look also at the OPC document for that one correction and that one update. But otherwise, there's stuff in, there's material. The chairman's not here, but he's correcting me for using that term in the past. There's material relevant to this case in the staff document that's not in the document that OPC intends to proffer. I'm not sure whether, other than the correction and the update, there is material in the OPC document that is not also covered in the staff document. But the way you make sure of that is that you have everything, absolutely everything, is to put both documents in.
I guess where my confusion lies is on the third document, where you said that there are pages missing from Staff Exhibit 2 that belong. So that's kind of where my confusion lies, because we've got Staff Exhibit 2, but then there's a third document. Is that going to be a different exhibit, or is that going to be...
I think it would be substituted for what we presented yesterday, Your Honor. That's my understanding. It's the same document. But there's a little more to it that I guess when it was given to me to copy and provide, it didn't have a couple of the tables in it.
And Mr. Cleaver, do you have a position on the substitution of Staff Exhibit 2?
Your Honor, if, as Your Honor describes it, the third document corrects the 2 errors in Staff Exhibit 2, then we have no objection to it at all.
It's my understanding that it does not. It's just simply some pages were missing. Let's say it was a 50-page document. What I'm hearing, and perhaps I'm hearing incorrectly, what I heard was that hypothetically, it was a 50-page document, but we only got 47 pages. And so it was just simply a copying error, not a correction of the errors that you have identified, which would then be discussed in your response to the data request that you are asking to be admitted.
That's a correct summary of the facts, Your Honor.
That is correct, Your Honor, and I would also submit that what may make the most sense for purposes of completeness, which we favor, is a fourth document that's a version of the third document in Mr. Trout's hand with the errors corrected. That would be the company's updated and correct revenue requirement schedule.
If
Mr. Spivak, I'm going to see if the staff has a position.
I think counsel for OPC is correct on that. It has to be marked separately, but that might be the best answer we've got, because it would be nice to have everything in one place and correct.
Mr. Trout?
Updated.
So if I understand this proposal that I am hearing now for the first time, it would be that in lieu of admitting either staff Exhibit 2 or the document that OPC was saying they would proffer, but they have not yet proffered, we would replace staff 2 with the complete version of the response to staff data request 14-15 corrected. So there would be, the company would then go back and create a corrected response to 4015. I believe that would be a perfectly satisfactory resolution as well, in that you would have all the data and it would be fully corrected and up to date, and you would have it all in one document rather than two. I agree. That's actually that would be the most efficient. The only drawback, and it's a procedural drawback, not a substantive one, is that no such document yet exists, so we'd have to go back and create a revised response to 4015. So, and I don't think we could get that done today, but we would have then a replacement version of staff 2 that folds into it the one correction and one change, one update from the document OPC was talking about entering into evidence. It would all be in one place. It would be complete. And the commission would have it all and would have the additional virtue of only having to look at that and not at two different documents. Yes, the company supports that outcome, and we would act expeditiously to create such a document, show it to the other parties, and then that could become staff 2, to which the company continues not to object.
Okay. So I'll ask staff and OPC, would that cause any difficulties with respect to cross-examination that you were planning to conduct today, that you would need to reference that exhibit?
Not for OPC, Your Honor.
Not for staff either, Your Honor.
I think that's probably the cleanest way to go about it, that then we have one document that is corrected, and then for our purposes it makes it it helps facilitate our review of the record instead of having to say, oh wait, no, we have to go back and look over here and then this one back here. So I think that I like that solution, and so I will, if all the parties are comfortable with that solution, we'll do that, and as soon as possible, hopefully no later than tomorrow morning, you'll have that revised, since we already know the apparently you already know the answers and what is incomplete, so it would just be a matter of making some adjustments.
Your Honor, just one caveat there is I don't know the nature of the update and the change they made at this point. It is possible, from my witness's perspective, that it might trigger a need to update either the comparison chart or one of their exhibits. I will consult with them later on today, and when we receive the document from them, they'll let me know that.
Okay.
And I can commit on behalf of the company to work with the staff and OPC. If there's some sort of ripple effect, we'll get that cleaned up as well. If after Your Honor rules, if we could go off the record for a couple minutes, I'll be able to get the process of creating this replacement document initiated, and I'll also be able to come, when we go back on the record, give you a timeline for when it will be done.
That sounds fine. Are the parties in agreement with that process, then? It's not going to cause any difficulty for the parties with respect to their the hearings today?
We're fine with that, Your Honor.
Okay.
No objection.
Well, that will be the ruling that we will not admit Staff Exhibit 2 at this time, and you will prepare a revised exhibit, which is currently Staff Exhibit 2, and review it with the parties. So that's the ruling, and we'll go off the record for a few minutes and allow you to get that moving as quickly as possible.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Yes, Your Honor. The Office of People's Counsel calls Dr. Karl Pavlovic.
I'm sorry, before we swear in the witness, Mr. Trout, do we have an update on the timing?
Yes, thank you, Your Honor. We will be able to provide the parties tomorrow morning with the updated response to 4015, and then first thing tomorrow, we should be able to get Staff Exhibit 2 into evidence and be done with this.
Thank you. And we will not admit OPC Exhibit 3, which was the partial response.
Understood and agreed, Your Honor. Thank you.
Okay, thank you. Okay, if you would proceed, Mr. Cleve.
Do you swear on a perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Dr. Pavlovic. Would you please state your name for the record?
It's Karl Pavlovic.
And would you please state the name of your business and its address?
It's PCMG and Associates. The address is 22 Brooks Avenue, Gaithersburg, Maryland.
Thank you. Dr. Pavlovic, do you have before you a document entitled Revised Direct Testimony of Karl R. Pavlovic, which was filed in this case on December 6th, 2018?
Yes, I do.
And does that document include 24 pages of narrative testimony, your curriculum vitae, exhibits KRP 1 through 5, and one data response by the company to a data request?
Yes, it does.
Okay. Your Honor, I would like to have Dr. Pavlovic's pre-filed direct testimony marked for identification as OPC Exhibit 8.
So marked.
Dr. Pavlovic, do you also have before you a document entitled Rebuttal Testimony of Karl R. Pavlovic, which was filed in this case on December 20th, 2018?
Yes, I do.
And does that document include 12 pages of narrative testimony and one data response by staff to a data request?
Yes, it does.
Your Honor, I would like to have Dr. Pavlovic's pre-filed rebuttal testimony marked for identification as OPC Exhibit 9.
So marked.
Dr. Pavlovic, do you also have before you a document entitled Surrebuttal Testimony of Karl R. Pavlovic, Public Version, which was filed in this case on January 16th, 2019?
Yes, I do.
And does that document include 12 pages of narrative testimony, 4 data responses by the company to data requests, and 5 data responses by OPC to data requests?
Yes, it does.
Your Honor, I would like to have Dr. Pavlovic's pre-filed surrebuttal testimony, the public version, marked for identification as OPC Exhibit 10.
So marked.
And do you also have before you, Dr. Pavlovic, a document entitled Surrebuttal Testimony of Karl R. Pavlovic, Confidential Version, also filed in this case on January 16th, 2019?
Yes, I do.
And does that document include 12 pages of narrative testimony, 5 data responses by the company to data requests, and 5 data responses by OPC to data requests?
Yes, it does.
Your Honor, I would like to have Dr. Pavlovic's pre-filed surrebuttal testimony, confidential version, marked for identification as OPC Exhibit 10C.
So marked.
Your Honor, also I've handed out copies to counsel and provided copies to the bench of the company's response to OPC DR 420. This is a confidential data response with a confidential attachment. This document had been attached to the original version of Dr. Pavlovic's confidential testimony filed on November 20th. That was the only thing that made that testimony confidential. When we filed the errata to his testimony on December 6th, we only filed a public version in order to minimize confusion. So the only difference is that it didn't contain this attachment, and we explained in the cover letter that we would be offering this as an exhibit. The company has agreed this morning, even though Mr. McGettigan is not here to sponsor it, that it would stipulate to the admission of this data response and attachment. So we would ask that that be marked as OPC Exhibit 11, and that is a confidential document.
I believe that's 12, Mr. Cleaver. Is it 11?
10C. Then
Oh, 10C, sorry. Sorry, yes, so marked, 11.
Dr. Pavlovic, were all these documents before you prepared by you or under your supervision and direction?
Yes, they were.
And do you have any corrections or deletions to make to your respective testimonies at this time?
No, I do not.
And if you were asked the same questions today under oath as were posed in your pre-filed testimonies, would your answers be the same?
Yes, they would.
For these reasons, do you adopt these direct, rebuttal, and surrebuttal testimonies, respectively, as your sworn testimony in this matter?
Yes, I do.
Your Honor, I move that OPC Exhibit numbers 8, 9, 10, 10C, and 11 be admitted into evidence.
No objection.
No objection, Your Honor.
They are admitted.
Thank you, Your Honor. The witness is now available for cross-examination.
Does the company have any questions?
Just a few, Your Honor. Good morning, Dr. Pavlovic. So, do I get that right?
That's one of the 5 acceptable
Okay.
pronunciations.
My name is Max Curran. I represent the applicant in these proceedings. I just have a few questions. Actually, did you have an opportunity yesterday to observe the testimony of company witness O'Black?
Yes, I did.
And my understanding from your testimony is that you have a disagreement with the company in connection with the jurisdictional separation study,
That's correct.
specifically regarding how those dollars are allocated. As I understand your disagreement, generally for those accounts for land and structure, you believe that those should not be directly assigned, but should basically be applied through a general allocator. Is that a general correct summary of your testimony?
Yes, that's correct.
You are not, though, however, claiming that any of those accounts, those investments or costs are in any way imprudently incurred. It's just how they are being allocated.
That's correct.
All right. And you don't disagree with the company that that plan is necessary for utility service. Again, it's just how that plan is allocated.
That's correct.
All right. And in connection with your testimony regarding the rate design, I understand you're covering cost of service, but also rate design in your testimony.
That's correct.
You understand currently that the company's residential customer charge has been set at $5 a month,
That's correct.
and that was set back in Potomac Edison's last rate case, some nearly 25 years ago.
Yeah, I think that was about 25 years ago.
Right, and it's remained, to your knowledge, at $5 since that time.
To my knowledge, that's correct.
And you've had an opportunity, as part of your testimony today, to review the other customer charges that are being charged by the Maryland's other utilities. Is that fair?
I'm generally familiar with the customer charges by other Maryland utilities.
And would you agree that Potomac Edison's residential customer charge is the lowest of those other customer charges being charged by the state's other utilities?
Yes, I would agree.
Okay. And your testimony, as I understand, is you do not want that charge to be increased.
I believe that charge should be based on customer cost. And as I calculate the company's customer cost, it's $5.13 currently.
So as a part of your analysis in this case, now again, this charge has been set at $5 since 1994. Did you factor in the impact of inflation since 1994 in making your recommendation?
Since my recommendation is based on what the company does basically a carrying charge calculation on its plant, its services and meters plant, and then allocates a portion of O&M to that. That's how the company calculates what its customer cost is. When I put into that calculation, Mr. Parcells recommended cost of equity and then rate of return for the company. Plus, I made a few corrections to the way in which the expenses are allocated, the O&M. What the calculation says is that the company's current customer charge for residential, customer cost for residential is $5.13, I believe. So on that basis, I guess the answer to your question is, by doing that, I have taken into account the effects of inflation, since I am using the company's costs, current costs, to calculate that.
I have no further questions.
Thank you, Mr. Curran. Mr. Spivak.
Staff has no cross with this witness.
Okay. Mr. Cleaver, any redirect?
No redirect, Your Honor.
Okay. Good morning, Mr. Pavlovic. Nice to see you again.
Nice to see you, Commissioner.
So, Mr. Pavlovic, I'll start with customer charge since we were just talking about that. In your view, if there were a large penetration of solar in the residential class for PE, would that be a reason to potentially increase the customer charge?
Only if solar penetration required some change in the company's service and metering arrangements. Mm-hmm. And then if it either cost less or more to have a service installed for solar, less or more to have a meter installed coincident with that solar. Mm-hmm. That effect would carry through in the calculation of the charge.
Does the prospect of a potential subsidy from those without solar to those with solar cause you any concern?
Well, if the cost were to increase, I mean, my recommendation would be that if a residential customer were to install solar and its customer costs were to increase, for example, by whatever the difference is in the underlying cost of the service and the meter, if there is any, my recommendation would be that there be a separate customer charge for solar residential customers. And in that way, there would be, if the cost actually were more, then there wouldn't be any subsidy created from the other residential customers. If it were less, then there wouldn't be a subsidy in the other direction.
Okay, thank you. Excuse me. Have the overall OPC recommendation is a rate decrease, correct?
That's correct.
So has OPC considered the impact of that reduction on the financial well-being of PE or the ability of PE to go out and attract capital?
That decrease is a function of, let's see, it's a function, that decrease is a function of Mr. Parcells' recommended cost of capital, Mr. Guerin's recommended depreciation rates, and my recommendations regarding the allocation of general and intangible, excuse me, and my recommendation concerning in the class cost study that the zero intercept minimum system study classification of primary, secondary lines and transformers not be used, so that that's 100% demand. All of those contribute to it. I think the answer is OPC has considered that has considered each of those changes and their impact on the company's financial well-being. So I think the answer is yes.
Okay. In your rebuttal testimony on page 4, table C, oh, maybe it's your sir rebuttal. Let's see. Nope. Maybe it's your direct. Sorry about that, I wrote it down wrong. Nope. I have no idea. Well,
I think did you mention a table?
table C, where is table C?
I believe my direct testimony, is my direct testimony the only testimony that,
With a table? They're all numbered. I must have been writing on the wrong page. Sorry about that, Mr. Pavlik.
no problem.
So, your position is that PE is over-allocating cost to Maryland because, for example, Williamsport provides some services outside of Maryland to West Virginia, right?
That's correct.
Right.
The land and the structures support some services.
Some services
that go,
in West Virginia,
that
right.
go to West Virginia.
So, would you expect that some of the, potentially some of the service centers in in West Virginia might also support Maryland?
I believe that's the case.
That's the case.
That the Berkeley Springs Service Center, which is located in West Virginia, provides some services are provided to the Maryland jurisdiction out of the Berkeley Springs
Right.
Service Center.
So, is there any potential that those two kind of balance each other out? That
No.
some services are here and some services are there.
No, there are many more services provided out of the Maryland service centers to West Virginia than there are, conversely, out of the West Virginia service centers into Maryland.
And on what do you base that determination that there are many more going out of Maryland instead of coming into
Well,
Maryland?
primarily based on, excuse me, let me recall. Well, among other things, but sort of my final determination is based on consideration of, in the first instance, the, what is this? Attached to my rebuttal testimony, there is the response to OPC 29.2.
OPC 29 point, what was that, 29.2, did you say?
29.2.
Okay.
And in particular, the attachment to that, which actually came up in Mr. Cleaver's cross-examination, I think, of Miss O'Black yesterday. What you have in this table, excuse me.
That's okay, Mr. Pavlik, I'm in the same boat.
I'm also coming down with a raging case of pink eye, which I got from my granddaughter,
Oh, goodness.
which makes it also very difficult for me to focus on the text here. You have 6 Maryland service centers listed here, and I think it's 1, 2, 3, 4, 5, 6, yes. And then you have the Berkeley Springs Service Center, which is a West Virginia service center down at the bottom. And what this chart does is that it indicates which services out of the Maryland service centers. There's a column called jurisdiction, and if you look in that column, you'll see, for example, the Cumberland Service Center, which is located in Allegheny County, Maryland. And then the next column, daily operations, describes what services are provided out of that service center. And the next column, entitled type, adds more detail in response to a data request that I asked as to what those daily operations consist of. And primarily the question was what distribution facilities or what facilities are serviced. Are they Maryland or are they in West Virginia? And then under jurisdiction is the answer to that question. And you'll see if you start over Cumberland and then under daily operations, you've got substations. And then under type, you've got operate distribution, subtransmission, and transmission substations. So that's what's done out of Cumberland. And then finally, under jurisdiction, the company explains this group primarily supports Maryland and is also responsible for several distribution substations located in West Virginia. Okay. That's also the case for the Williamsport Service Center, which is also in Washington County, Maryland. And if you read across on the Williamsport one, you will see that the substations group in Williamsport is primarily supports Maryland and is also responsible for several distribution substations located in West Virginia. In addition, out of Williamsport, the controls group, it says this group is responsible for distribution operations in all of Potomac, Edison, which includes Maryland and West Virginia. If you look at Berkeley Springs, the one West Virginia service center that is located in Morgan County, West Virginia, what it indicates is that that service center provides only meter reading and collections services. It says this group primarily supports West Virginia and is also responsible for reading meters and performing locations in Hancock, Maryland. That's the only, according to the company, that's the only service that's provided in Maryland by a West Virginia Service Center. I think I'd like to also add, if I may, Mr. Cleaver had asked Ms. O'Black about this note that's at the very bottom, which says that when daily operations require state boundaries to be crossed, costs are allocated according to the cost allocation manual. At the time that I read that, I thought that was a reference to the NARUC manual. But as Mr. Cleaver elicited yesterday, it's actually a reference to Potomac Edison's cost allocation manual, which was provided as a exhibit of Mr. Valdez's exhibit REV 21. This allocation manual has to do with how First Energy allocates to its various operating companies administrative and general service, the costs of administrative in general, and also services provided by the First Energy Service Company. It has nothing to do with the allocation amongst jurisdictions of a single subsidiary. If you look at it, it's actually a very interesting manual and document, and explains how, in fact, they allocate those costs, those First Energy and Service Center.
Right. Yeah. I understand. I understood it to be the CAM. So that's something that.
I just wanted to point out,
yeah.
but I wanted to point out, given that it's attached to this table, which talks about operations across the jurisdictions for Potomac Edison, there's nothing in this manual about allocating costs to Potomac Edison and Maryland and West Virginia.
Right, I understand that. Thank you. So, in your view, would the change in PE's, the growth and the change in their service territory, changes that would have taken place over the last 25 years, would that have an impact on the jurisdictional separation study in your view?
Well, the jurisdictional separation study is based on both costs and metrics for Potomac Edison for 2017. So it reflects the state of Potomac Edison in 2017, and I presume that the effects of growth changes in their operation, whether it's increase or decreases, are properly reflected.
Mm-hmm. Well, staff has made a proposal on the jurisdictional study. Do you have any comments on the staff proposal?
Actually, I have a number of questions for Mr. Cleaver to ask Witness Baker.
Uh-huh.
But I can respond to your question, which is Witness Baker has on page 1 of his testimony, he has a number of recommendations, and 3 of the recommendations appear to say that Potomac Edison should do the separation study, that do it the way they did it. He then has, I think it's from pages 4 to 13, he has a very extended discussion of the way in which he believes Potomac Edison should be allocating general and intangible plant. It's not complete, as he said. I mean, that is the numbers that he calculates, the instructions that he gives and that he recommends for conducting that allocation that portion of the allocation study, or the separation study, is not really complete, and he has to make some assumptions and things like that. What I don't know is which of those things he's recommending. Is he recommending that extensive discussion of the allocation of general and intangible plant to be done in the next rate case for the company? Or I think that's what you're asking me about, that extended discussion about how to do lands and structures and the other, excuse me, general
Well, he has a
plans.
proposal, he has a proposal for what we should do with respect to this proceeding, right? Not what they should do in the future, but he has proposed, studies, we should do this instead of, PE did this and OPC says this, and we should do, I kind of think it's sort of maybe somewhere in the middle. OPC staff's suggestion is kind of trying to reach a compromise, and I was just wondering what your view was of that compromise position for developing rates for this case.
Okay, to go back to there are his what he labels as his recommendations, which on page 1, which I read as supporting the company's method. With this other stuff, I guess my feeling is it might be the right way to do his allocations, but he hasn't completely done them in this case. And to implement that, I mean, I don't see, as a practical matter, how that methodology could be implemented for this proceeding.
Okay.
As it stands, he has a number of significant assumptions that he makes, and then he says, well, the company could do this, it could do a study this nature, it could do a study of this nature to come up with the exact numbers. And looked at that way, it's entirely likely that would be the best way to do the allocation. But I don't see how it can possibly be done for this case.
Okay. Thank you very much. I believe that's all I had. Commissioner Richard?
Morning, Mr. Pavlovic.
Morning.
Actually, my questions really were around just compare contrast your position with Mr. Baker from staff, and you may have just answered the first one about Mr. Baker's approach to handling allocating intangible and general plant. It just struck me that it seemed like he is agreeing with you, but he was just being maybe a little more precise in separating allocations, for the service centers that serve West Virginia and Maryland, and then going on and using a labor allocator as, again, really getting to the real work that's being done in these service centers. And then he also talks about, I think, the distribution and transmission, considering those functions as well, functionalization. So, I mean, you may have, again, just answered the question for Commissioner Herman, but is that correct, that you essentially in the same place? It's just maybe he's gone into a lot more detail and how he would go about the allocation.
With regard to general plant, the NARUC manual that's been discussed, suggests that there are 3 different approaches that you can take to the allocation of general plant. Mm-hmm. One is to simply use a plant allocator. And what that means is that you take the allocation of transmission and distribution, mm-hmm. and that's how you identify the distribution portion of the general plant. One is to use a labor ratio where you take basically develop labor ratios for all of the distribution functions, the distribution function itself, customer accounts, customer service, and sales. Mm-hmm. And then there's a third one, which is to take on an account by account basis, that is from 389 to 399, to develop specific allocations based on cost causation for each of those. I understand Mr. Baker to be saying that's the approach that should be taken, that third approach. And You have to understand, cost analysis is an empirical science. All right. It may be that that is the best way, in the case of Potomac Edison, to come up with the proper allocation of general plant for Potomac between the Maryland jurisdiction and the West Virginia jurisdiction. But it's very time consuming. It's one thing to say conceptually, it's another thing to develop the metrics that you're going to use to allocate each of those. If it were done properly, I don't think I would have any objection to to Potomac. You know, based on cost causation, various allocators for each of the accounts were selected, and then metrics developed for them. That would probably that would give a more precise answer to the question.
Okay, that's helpful. I'll ask Mr. Baker then, if he thinks it would be a very laborious task to try to get all the information. Also, I believe you support Mr. Baker's cost of service study, or cost of service recommendation without the zero-intercept study. While it's 32 years old, this study, I think Mr. Baker is recommending an approach that gives some weight to that study, in the interest of making sure that there's a fair allocation between residential and non-residential customers. Do you want to comment on that? Do you think some weight should be given to that study? And Mr. Baker also recommends a new cost of service study, but at the same time, with and without the zero-intercept methodology. But for the here and now, should we give some weight to that old study?
I think not. You should not give any weight to that study. And the reason that you should not give any weight to that study is that it simply assumes that there's a portion of the primary, secondary lines and transformers that is caused by customers. Whereas the test of whether any of those facilities are in fact caused by customers and some portion can be said to be customer related is whether you can demonstrate that in fact the number of customers causes that some portion of that cost, some portion of those facilities. And I don't know that I have never seen a company produce a demonstration that the number of customers actually causes some portion of that. There certainly is no demonstration of that in the record here.
Okay, so you reject then Mr. Baker's his cost of service recommendation that gives some weight. You would to the previous study and just throw it out altogether and go with this.
Yes,
out.
That's my recommendation.
Okay, great. Thank you very much.
Good morning.
Good morning.
I don't have many questions for you, Mr. Pavlovic. I wanted to clarify something in your SIR rebuttal. If you could take a look at page 4 of your SIR rebuttal testimony. Starting on bottom page 3, you say that in your rebuttal to direct testimony of witness O. Black that she makes 3 assertions, and the second one at the top of page 4, lines 1 and 2, is that the NARUC manual. Could you clarify for me what the NARUC manual is? The NARUC manual is NARUC has many manuals, so remind me what the manual is.
It is the Electric Utility Cost Allocation Manual.
Okay. So the NARUC manual on electric utility cost allocation provides support for the use of labor ratios in allocating general and intangible plant. And then you respond to that down in line 16 through 20, and You say while the NARUC manual supports the use of plant ratios, labor ratios, or account-specific ratios, it does not support the use of labor ratios applied to general plant directly assigned to jurisdictions. So here's my question. The NARUC manual, in my understanding of it, lists several methodologies that utilities could use in this regard. But does it prohibit, does it specifically say, is it exclusive to their recommended or listed methodologies? Is it exclusive to that list? Or does it outright recommend that the methodologies proffered by witness O. Black should not be used? Does it affirmatively say, no, you shouldn't do that?
No,
Okay.
no. In fact, the manual nowhere, to my knowledge, says that about any methodology.
So there could be other methodologies that are acceptable and consistent with the NARUC manual, correct? That's the assertion of Ms. O'Black in her testimony yesterday. It's consistent, it's not prohibited, and it's okay. Is that
So long as that methodology is consistent with cost causation.
okay? Well, I agree with that, but
Yeah.
you say it's not supported by the NARUC manual, and that's kind of a broad statement. I wanted to clarify that it's not recommended again.
No, that's right.
Okay.
No, I was responding to Ms. O'Black's statement that it was supported.
And then I also asked about the load profile changes in the PE service territory in Maryland yesterday. The changes maybe in the residential class, the changes, dramatic changes in the commercial and industrial classes that have occurred since the last base rate case. Would you comment on how that could affect the cost of service study that's being relied upon here? I mean, couldn't it dramatically change what? And
Well, it could dramatically change the allocation of certain facilities to the classes based on how they were allocated in 1994. But I would also say that those changes, I mean, whatever those changes were, they are in fact reflected in this cost study. I mean, this cost study is based on costs and allocation metrics that exist today in Potomac Edison's.
right, but aren't there a lot of subordinate studies that support that haven't been updated? That are factored in?
Yes, but my understand. I think there's no question that if Potomac Edison were to update those supporting studies, although they're not, I mean, my understanding is that those studies support the customer-related allocation of the primary and secondary lines thing. There would be a very significant difference in the results of those studies if they were done today.
Okay.
Because you're right, there have been dramatic changes both in the way electricity is produced and regulated, and there have been changes in the service territory of Potomac Edison that would undoubtedly create different results from those, from the results that the studies had back in the 90s when they were done.
Very good. Thank you, sir. That's all the questions I have.
Thank you very much, Mr. Pavlik.
Thank you. Take with me anything I touch.
Yes.
Please.
We got this. Can we go off the record for a moment, please? We're back on the record. Mr. O'Loughlin, call your next witness.
Thank you. Good morning. OPC at this time, I'd like to call David Parcell.
Please swear and affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth.
Yes. Good morning, Mr. Parcell.
Good morning.
Could you please state your name for the record?
David C. Parcell, Parcell.
And what is the name of your business?
Technical Associates Incorporated.
And the business address?
1503 Santa, like Santa Claus, Santa Rosa Road, Suite 130, Richmond, Virginia, 23229.
Do you have before you a document titled The Public Direct Testimony of David Parcell, consisting of about 39 pages, filed on November 20th, with your CV and about 14 schedules?
I do.
I'd like to mark that as Exhibit 12, please.
So marked.
Do you also have before you a document titled The Confidential Direct Testimony of David Parcell, also consisting of 39 pages, filed on the same date with your CV, 14 schedules, and one confidential attachment?
That's correct.
I'd like to have that marked as 12C, please.
So marked.
Finally, Mr. Parcell, do you also have a document before you titled The Surrebuttal Testimony of David Parcell, consisting of 15 pages and two two-page exhibits filed on January 16th, 2019?
The reason I'm hesitating here, I think the exhibits were filed a couple of days later.
Yes, they were filed. They were filed with that. It was we corrected an error in not attaching them, but they were filed with the surrebuttal.
Otherwise, the answer is yes.
Thank you. I'd like to have that all marked as exhibit lucky number 13, please.
So marked.
Were these all prepared by you under your supervision or at your direction?
Yes, they were.
Do you have any corrections or deletions to make to any of these testimonies?
No.
And if I were to ask you the same questions today under oath, would your answers be the same?
They would.
I'd like to move exhibits 12, 12C, and 13 into evidence.
Hearing no objections, they're admitted.
The witness is available for cross-examination.
Good morning, Mr. Parcell.
Good morning.
Nice to meet you. My name is Max Curran. I'm counsel for the Potomac Edison Company.
Pleased to meet you.
My understanding, sir, is that you've had an opportunity to testify before this commission on behalf of the Office of People's Counsel before. Is that correct?
That is correct.
In fact, I believe you testified rather recently in a Washington gas light matter just a few months ago.
That is correct.
And in preparation for your testimony today, did you have an opportunity to review any prior commission decisions in connection with the Baltimore Gas and Electric Company?
I have a file in my office of several recent commission decisions.
But specifically,
I know that two of those I reviewed are PEPCO decisions, but I can't specifically recall a BG&E decision. It may be there, but I don't recall specifically, so I don't know if I reviewed that or not.
no recollection of reviewing a decision regarding their combined gas and electric base rate proceedings?
I'm aware of the commission decisions as to return on equity, but I do not recall specifically reviewing the decision itself. I may have, but I don't recall.
Any recollection of reviewing any prior decisions that articulate the commission's precedent and that they review or view a company's electric operations of being slightly more risky than their natural gas operations?
The short answer is no. I have information which I thought was in my banner, which is not that I could compare the actual authorized returns, but no, I do not have any specific recollection of commission wording as to electric versus gas.
Well, would it surprise you that that is the commission's prior precedent, that they view electric operations as being slightly more risky than gas operations?
Yeah, that's simple. It would not surprise me. Yes.
Thank you.
I can accept that.
And then again, you mentioned you had an opportunity recently to testify in Washington Gas's recent base rate proceedings. I believe it's case 9481.
That is correct, yes.
And in that case, you had recommended a return on equity of around 9.4. Does that sound right?
That's correct, 9.4%.
All right. And I believe as part of your testimony, you had recommended, I guess, to place some downward pressure on the, and those are my words, but downward pressure on your recommended ROE based on the fact that Washington Gas in Maryland enjoys the opportunity through the stride surcharge to get accelerated rate recovery for certain investments. Is that right?
I did observe that they had the STRAD program. I did observe that the STRAD program was risk reducing. What I don't recall is whether I recommended, as I did in this case, that program just should result in the company's ROE being set at the midpoint of the proxy group, or whether I made a specific downward adjustment. I don't recall.
Well, you agree that the you agree that the stride mechanism for gas companies in Maryland is risk reducing.
That's right, but I don't recall if I made a specific downward adjustment for it. I don't believe I did, but I don't recall specifically.
Okay. Would you agree with me, though, that electric companies in this state do not enjoy a similar stride mechanism?
Not the same mechanism, but it's my understanding that the proposed surcharge that's being requested in this case is similar to it, but that's not my specific area of expertise, so I can't really compare the two. But the company is recommending or asking for a similar type of surcharge.
And you agree with me that the Office of People's Counsel, who you're testifying on behalf today, has recommended that the Commission reject that proposed surcharge mechanism for Potomac Edison?
Yes, and I so stated in my testimony.
Thank you. On page 13 of your direct testimony, if we could turn your attention
Sure.
to that, sir. You have a discussion, I guess it's beginning on page 12 and going over to 13, describing First Energy, as well as the current security ratings of PE and First Energy. Do you see that?
I do, yes.
Okay. Would you agree with me, according to your chart, that the senior unsecured credit rating for Potomac Edison is BBB minus?
Yes.
And is that your understanding that they continue to have a BBB minus rating today?
I'm sorry, repeat that, please. I missed the word.
Would you agree with me that Potomac Edison continues to have a BBB minus rating today?
That's my understanding, yes.
There hasn't been any action changing that rating since you filed your testimony.
That's correct, yes.
And you said earlier that you had you testified in Washington Gas's most recent base rate proceeding.
That is correct.
And would you agree to me, and again, subject to check, that Washington Gas enjoys an unsecured debt rating of BBB plus?
Yes, they had just been downgraded as a result of their merger by Alta Gas Limited, a Canadian company. But I believe at the time of the hearing, the downgraded amount was BBB plus, yes.
All right, thank you. And did you, perchance, read the Commission's decision in the Washington Gas proceeding?
Yes, I did.
And would you agree with me that they granted an opportunity for Washington Gas to earn a 9.7 ROE?
9.7 is correct, yes.
And as part of your preparation for today, did you, I think I asked you this, but did you review the Commission's decision in the recent BG&E gas rate proceeding?
You did ask me previously, and I did not recall.
You don't recall. All right, thank you.
I've reviewed several, but that one I don't recall one way or the other.
All right, thank you. That's all I have, Your Honor.
Thank you, Mr. Curran. Mr. Dean?
Good morning, Mr. Parcell.
Good morning.
Staff has no questions for you. Thank you.
Any redirect?
No, Your Honor.
Okay. Mr. Parcell, I have a couple of questions for you. It seems like in this case there's quite a wide variation in the size of the proxy group. Yours, I think, has 8, the staff has 33, and the company has 17. Is that right?
What's right? The company has 17, and I have 1, 2, 3, 4, 5, 8. But
Right.
I also apply my return on equity methodologies both to my proxy group and the company's proxy group. So I use 2 proxy groups, mine and the
Right.
company's. Of course, I could not do the staff because we filed at the same date.
Right, I understand that. But would you expect any different results, if you had a smaller proxy group versus a much larger proxy group? For example, your proxy group is, 3, much smaller than staff's. Would you expect that would have any impact on the results of the various tests?
If you have a smaller proxy group, there is a possibility that one company whose results produce outlier results, extreme results, would have more of an influence on a small proxy group than a large proxy group.
Okay. Would you have a sort of a diffusing effect with a large proxy group? Similarly, on the
Yes,
other side?
it would minimize the impact. As a complex, say, on the other hand, when you go from a small proxy group allows you to focus more closely to the subject company to get more comparable. In a large proxy group, because it's more of them, and that they'd be less comparable. On the other hand, the small group, one company could influence results more than a large group, so it's kind of a mixed bag.
Gotcha.
And that's
Okay.
why I like to use both my group and the company's group. But again, I could not do the staffs.
Right. So, Mr. Parcell, just sort of as a general question, if you have results of performing one of your studies, and the range, for example, the range is, you've got like, 0.5, relatively small differences in the results when you're creating a range, right?
Right.
Now, if the range were for much larger, if the results of your study created a range that were, instead of here, would that cause you any concern? With the large size of the range.
Well, answer is yes, and it happened here. I used 3 methodologies: DCF, comparable earnings, and capital asset price model, CAPM. And I found that the CAPM results were much different, much lower than the comparable earnings in DCF. And as a result, whereas I do the CAPM and I cite the CAPM, the CAPM results did not factor into my recommendation because of that diffusion.
Right, but what I'm talking about is you have about a 0.5% difference, in your range.
Overall range.
Overall range.
I'm sorry, I think I
And
misunderstood
so,
the
and
question.
I'm looking at, the staff, for example, has 5%, or almost 5% difference between its range. Would that large of a range cause you to have any concern with the study that was performed?
No, I mean, that would not bother me vis-a-vis the staff, for example, who is the bigger or smaller, because we both focus on the midpoint anyway. So how you get there, I don't think is that important.
It doesn't matter.
I mean, you've got it's where we pick within the DCF range, the per earnings range, the CAPM range, that creates the overall range, and that's where the judgment comes into play anyway. So that does not give me a lot of heartburn. No.
It doesn't give you heartburn to have one range that's 5% off in most of the other ranges, which are 0.5%.
No.
Okay.
No.
All right. Thank you. So can you? I know you didn't use your CAPM because the results came out so low, right?
I did. The results did not factor into my recommendation
right.
or conclusions. No.
Okay. So to what do you attribute the much lower result than the others?
Well,
test?
A primary component of the CAPM is the so-called risk-free rate, and the risk-free rate that's universally used is the yield on long-term Treasury bonds. And long-term Treasury bonds have been held down for the last several years by the Federal Reserve's quantitative easing, or QE, program, which was designed and appears to have been successful in getting us out of the Great Recession, which began in 2008. So these rates have been artificially, the Treasury rates, as opposed to corporate rates, but Treasury rates have been artificially low. And that's the major component of the CAPM. So to include a methodology whose rates are artificially low, I think results in artificially low conclusions. So I chose not to use it.
So, but that didn't appear to happen with, PE's CAPM and staff's CAPM. So why would that have impacted your CAPM potentially more than theirs?
They use projected growth rates. And as I show in my cerebral testimony, if you'd use projected growth rates over the last several years, in almost every year you would have overestimated the cost of capital because the projections were not realized.
Okay.
And investors are not dumb. If projections overestimate for 5 years in a row, they'll probably overestimate this year too.
Okay, thanks. I have a question, and I'm going to try to ask it, and hopefully it makes sense. But your recommendations are based on a combination of the results from your proxy group and of applying your test and your assumption to your proxy group as well as to the company's proxy group. Is that correct?
That is correct.
Okay. So how did you combine the two to develop your result?
When I looked at the results of my DCF and my comparable earnings, I had my DCF results that applied to my proxy group, and my DCF results that applied to the company's proxy group. I put those in a big pot together. That's one set of results, and the same with comparable earnings. So when I reach into the DCF pot, I'm grabbing both my results and Mr. DeCindis' results, and same with my comparable earnings. So I combined them to create a DCF range.
You combined. Do you average them, or did you sort of say, my low point was here and their high point was here, and that's the range?
Yes. I looked at both the highs and lows of both my group and his group, both for DCF and comparable earnings, and that formed the range, yes.
And you picked the lowest of the lows and the highest of the highs?
Yes, as well as the midpoints.
As well as the midpoints.
And means and averages, yes.
Okay.
I looked at them several different ways, let's put it that way.
Okay. Thank you very much, Mr. Parcell. That was all I had.
Thank you.
Commissioner Richard?
He says we're asking questions about CAPM and that type of thing. I am kind of interested why, what the rationale is for I guess, throwing out the empirical CAPM model. And that's what you do, is that you don't even do the model at all?
No.
Run it all? Okay. And I guess if I'm reading correctly, the reason you don't is because you say that just automatically the betas, it basically takes low beta companies and artificially or, gives upward pressure on the overall rate. But by so doing, aren't you in a sense also kind of skewing? I mean, you're doing that specifically for, I guess, low risk companies specifically. But if you're going to do a fair analysis across all companies, again, doesn't that skew the overall results? Should we consider both high and low risk companies?
I don't think so. I mean, let's look at beta from a standpoint of how it's developed. If you we're a subscriber to Value Line. Value Line publishes a sheet for each of its 1,700 companies in its standard edition 4 times a year. And the sheet is just covered with information. Historic, current, estimated. One piece of information on that sheet is the beta. And Value Line's beta is based upon 5 years of data. And Value Line adjusts this beta in a way that brings low beta companies toward 1 and high beta companies down toward 1. That's their adjustment process. And that's the stated reason by Value Line for doing that is to recognize that a tendency of some companies to be a long ways away. I mean, the whole purpose is to avoid the skewness. So a typical investor reading Value Line would have some understanding of what beta means, but almost no understanding of how beta is calculated. In my opinion, the last thing an investor is going to do is pick up a Value Line and get out his calculator and do his own adjustments to Value Line's beta. That's not what you buy. That's not what you pay Value Line. You pay them to do it for you, and that's what their best bet is.
Okay.
And Value Line's beta is very similar to Bloomberg's, so it's not just Value Line. Bloomberg, by the way, is 3-year betas. So it's like the spaghetti jar commercial. It's already in there. You don't have to do it. That factor is already incorporated.
Okay. All right. I guess I was just concerned that we might be, not considering what investors are looking for. When they're looking for all the different ways that they can, invest their money, they are looking for a certain return. And if we, again, don't look at all the different ways of evaluating a utility company against all the other types of investment, and if we're just throwing out the empirical capital asset pricing model, are we in fact giving investors, considering what investors are requiring when they make a decision as to what industries to invest in and what companies to invest in?
Yes, we are. Let me tell you exactly how. The purpose of betas, just like the purpose of investing, is to create a diversified portfolio for someone's own securities. So how do you diversify? Well, suppose I'm an old dude who's very risk averse, both of which apply to me. If I wanted to have a low-risk diversified portfolio, I could choose several low beta companies. And I diversify by having several companies with low betas. Or maybe I'm a different investor. I want to have a different perspective. There I might want to pick a few low beta companies and a few high beta companies to create. The high beta companies maybe give me a chance to hit a home run occasionally. The low betas, you'll get a lot of singles and maybe an occasional double. But if you want to hit a home run, you go for the high beta companies. That's where you make a big event. So there you'd be using betas to help diversify your portfolio, and it's factored into what you were saying. That's how you use betas to diversify. And you can do it with low betas, high betas, or combination, depending upon your risk tolerance and your objectives.
Okay, so that's why you don't think that we need to have that extra data point for our consideration here, because it kind of goes to when you're looking at the various parties and their range, and they try to find something kind of in the middle, the median or average. Yeah. Since you don't have something like an empirical capital asset pricing model analysis, doesn't that automatically then skew your results automatically to the very low end?
It would create lower results, but that don't mean they're skewed.
Okay, I didn't mean skew, but
it'd be lower.
It results in lower.
Of course, mine are. I don't consider mine in my recommendation anyway because they're quite low.
Mm-hmm. Okay, I guess the other question I have, this commission, we were very, the concept of gradualism is very important, and here we have a case where the current return on equity is 11.9. And you're recommending it's 9.2. Is that correct?
Right.
I mean, since you do these analysis around the country and you have a lot of experiences with, the impacts of making these recommendations on a company, is there any risk of going to such an extreme, making such an extreme, I would argue, ungradual move of an ROE from 11.9 to 9.2?
That's a great question. The reason you've got 11.9 is it was set 25 years ago in 1994. If the company had a rate case in 2012, they wouldn't have 11.9 ROE.
And I fully recognize that, but that's what we're facing right
Right.
now. And the company that is at this level, what will the market, think about Maryland if we suddenly go from an 11.9 for this utility down to 9.2?
Well, I cannot imagine a portfolio manager or a stock analyst telling investors with a straight face that Potomac Edison is entitled to 11.9 ROE because it's 25 years old. Any portfolio manager or analyst would know that these things are normally reset periodically. Mm-hmm. And like I said, I have done this a lot, and I was in a case a couple years ago in Ohio involving Dayton Power and Light, and their last rate case was 1992. Mm-hmm. Other than those two, I can't recall any case that was more than 5 or 10 years. That's just not the norm.
Yeah, no, I understand.
And it's not my job to say they should have been in or why, whether they should have come in or not. But the 11.9 is there because they have chosen not to come in 25 years.
Okay,
it's not your fault. It's not my fault.
Get it. And I think the company itself is with adjustments, requesting 10.8, and if we were to take out the flotation cost, the financial risk, the other risk, it's more around 10.
Right.
But, 1.
Yeah. But gradualism is not having a case every 25 years either.
Yeah. Okay. Very good. Thank you.
Good morning.
Good morning.
We're close. So I reviewed, Mr. Parcell, your resume. That's attachment 1 to your direct, and I was impressed. You've done over 550 rate cases between state and federal agencies for various
I'm old.
Various sectors. Welcome to the club, sir.
I testified for the first time in 1972, so it's been around for a long time. I had a chance to do a lot of them.
It looks like great scholarship, authorship, a lot of articles. And I wanted to ask your opinion of something. I recently attended a workshop at the Aspen Institute on economic theory, market theory, and utility rate setting. And one of the facilitators at the workshop was a guest presenter, similar credentials. And I asked him a specific question about his opinion of flotation costs, and do they rightly belong, if there are to be such things, and what's your opinion of such things? Do they rightly belong with the ratepayers, or do they rightly belong with the investors and the transactional side of the issuance of equity? And he said, I'm going to paraphrase, and I won't attribute to who said it, but he essentially responded to me that there shouldn't be such a thing because they should be born away from the ratepayers, separated from the ratepayers. And there's no indication that these companies, when you're doing a rate case, are going to run out and issue stock, and it's going to, there's going to be an issuance of equity related to the rate case. So that was his response. What's your response?
Well, there's a lot of complications here with flotation costs. The simple one to explain is that a person buying stock notices this cost associated with the sale of the stock, and that's factored into the price they want to pay. Now, if you go beyond that, how do you get flotation costs? Well, suppose you have a parent company has a dividend reinvestment plan. Shares are issued from dividend reinvestment, but they have very little flotation costs because there's no broker involved. It's just that the investor reinvests in dividends, or maybe occasionally having a cash addition to that. So for reinvested dividends, there'd be very little, if any, flotation cost. Now, how about a public offering? Well, public offering would have flotation cost. Well, who does it apply to? Well, you may have a small company like Southwest Gas Holdings, which has one subsidiary, Southwest Gas Company. Well, if Southwest Gas Holdings sells common stock, most of that money is going to Southwest Gas. So you know that the utility is using the proceeds of the stock sale. Well, here you've got First Energy, which has 10 subsidiaries. 10. And those subsidiaries are in different states. I mean, PE is in Maryland and West Virginia. Well, how do you allocate those stock sales and any flotation costs involved to the individual companies for recovery from ratepayers? It'd be almost impossible. Plus, in the case of First Energy, when they saw the wisdom of getting out of the non-regulated business a few years ago, they wrote off tens of billions of dollars, such that their common equity, I'm on my Schedule 5, page 2 there, their common equity went from $12.5 billion in 2015 to less than $4 billion in 2017. That's a write-off of $8 billion. Over two-thirds of their equity got written off. And the equity ratio went from 36% to less than 15%. So it would just make sense that any stock issuance by First Energy would be to bolster up the parent's consolidated capital structure, not PE. PE's got an equity ratio of 53%, which is a touch on the high side, but it's in the ballpark. So there's just a lot of complications involved with recovery of flotation costs, and they're all pretty problematic.
And in the instant case, you recommended that not
That is correct.
be allowed. In fact, there are 3 adjustments. So Mr. Diascendis comes up with a 10.1 recommendation and then adds these 3 adjustments, one for flotation costs, one for size risk of 30 basis points, and then one for financial risk at 27 basis points, taking his estimate up, or his recommendation up to 10.79 or rounded to 10.8. You indicate in your testimony that would cost the ratepayers, those 3 adjustments alone, if added together, would cost the ratepayers $2.314 million a year.
Well, those are my estimates. I asked the company witness through discovery what the impact of each recommendation was, and I put those as exhibits in my testimony. So those are actually figures provided by Mr. DeCensus.
Okay. So,
But yes, they're quite substantial.
I just wanted to check my understanding. You recommend against all 3, correct?
All 3, yes. I mean, in particular, the one involving financial risk, because Standard & Poor's is one agency that specifically ties the debt ratings of a subsidiary to its parent. And in my confidential testimony, can I say that? I can't say that.
We have to go into confidential session if you.
Well,
if it's confidential.
it's in there.
Okay.
It's in there.
It's not necessary.
Go find it.
It's not necessary. Thank you. I think I know what you're referring to. So, one last question: how ubiquitous is the use of the ECAPM methodology in your experience in utility rate cases?
It's proposed by almost all utility witnesses. Proposed, and it's opposed by almost all non-utility witnesses.
So non-utility witnesses don't use it, and utility witnesses
That's
do.
pretty much the case, yes.
Okay. I had a sense that was the case, but I wanted to.
And it was invented by a utility witness.
Well, I mean, that doesn't. I'm not speaking to its efficacy at all, but I wanted to get your experience as to how widespread its use was, and
Yes.
you've answered the question.
That's my view, yes.
All right, very good. Thank you, sir. I appreciate it.
Seeing no further questions, thank you very much,
Thank
Mr.
you.
Parcell. We'll go off the record just briefly, because I'd like to, are we off the record? I'd like to have staff, I believe we're on staff witnesses now, and I'd like to know the order in which the staff witnesses are going to be appearing?
It's my understanding that the order is Mr. Valcarengi, followed by Ms. Polbereski, Mr. Baker, and then Mr. McAfee.
McCall.
Followed by Mr. Lowe and Mr. Vanderhayden.
Thank you very much, Mr. Dean. We can go back on the record.
Staff would like to call Mr. David L. Valcarengi to the stand.
Please swear to affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mr. Valcarengi.
Good morning.
Could you state your position here at the Commission?
Assistant Director of Accounting.
Thank you. Do you have before you a document entitled Direct Testimony of David L. Valcarengi, dated November 20, 2018, consisting of 21 pages of testimony and exhibits?
I do.
Was this document developed by you or under your supervision?
It was.
And if asked today, would the answers in this be the same?
They would.
Thank you. Staff would like to mark this as Staff Exhibit number 11.
So marked.
Do you have any changes or corrections to this document?
I have one change to note. The exhibit attached to the testimony, DLV-1, there's a heading at the top of the page. It says case number 9473. That should be 9490. Other than that, I don't have any other changes.
Second page from the end. Thank you. Do you have a second document entitled Sir Rebuttal Testimony of David L. Valcarengi, dated January 16, 2019, excuse me, consisting of 9 pages of testimony and exhibits?
I do.
And was this document also prepared by you?
Yes, it was.
And do you have any changes or corrections to this document?
No, I do not.
And if asked the questions, your answers would be the same today?
Yes, they would.
Your Honor, I'd like to mark this as Staff Exhibit number 12.
So marked.
And I'd like to move exhibits number 11 and 12 into the administrative record.
Seeing no objection, they are admitted.
Thank you, Your Honor. Staff's witness is available for cross-examination.
Does the company have any questions?
Just a few, Your Honor. Good afternoon,
Good afternoon.
Mr. Valcarengi. Good to see you. You were testifying on behalf of staff today
I am.
regarding a number of issues, including depreciation rates.
That's
Is
correct.
that right? And it states in your testimony that you have had some experience in the past developing and analyzing utility revenue requirements as well as depreciation rates.
Yes,
You filed your direct testimony in this case on November 20th this year, last year. Is that correct?
that's correct.
And on page 3 of your direct testimony, you had recommended the Commission direct Potomac Edison to conduct and file the results of a depreciation study within a year of the issuance of this order. Is that right?
On page 3,
I believe it is page 3 of your direct.
that is the ultimate recommendation, but I don't think the page citation is right.
That's my error. I apologize. Now, on that same date as November 20th, Mr. James Guerin, on behalf of the Office of People's Counsel, also filed testimony. Is that right?
He did.
And you had an opportunity to review Mr. Guerin's testimony.
I have.
And thereafter, on January 16th of this year, you filed your sur rebuttal testimony. Is that right?
I did.
And if we take a look at page 2 of your sur rebuttal testimony, starting on lines 5 through 6, you say that Mr. Guerin, I'm sorry, OPC witness Guerin, are you there? I'm sorry.
I am.
Can you take a look at your testimony on page 2?
Yes, I have it.
You state here that Mr. Guerin performed a life analysis based on information received in discovery. You see that?
I do.
You did not characterize his analysis as a depreciation study, did you?
I think we're splitting hairs at this point, whether it's a life analysis or a depreciation study. I think the intent behind witness Guerin was to perform a depreciation study. Whether I call it a life analysis or a depreciation study, I think that we can quibble over the words.
And it was based upon discovery that he received. That's your testimony.
Yes, I believe the company provided information in response to a data request from People's Counsel.
Right.
I think it was 7-22 to be precise.
I think on page 3 of your sur rebuttal, you say that as a result of Mr. Guerin's testimony, he's recommending a 48% reduction in depreciation expense. Your calculation.
That would be the ultimate conclusion if the recommended rates recommended by Mr. Guerin were implemented, would result in approximately a 48% reduction in P.E. Maryland's depreciation expense.
Well, after reviewing Mr. Guerin's testimony, you did not change your recommendation of seeking that the company perform a depreciation analysis, did you?
No, I believe the commission should direct P.E. to perform a depreciation study.
You were not accepting Mr. Guerin's recommendation of a 48% reduction, did you, in your sur rebuttal testimony?
Well, if you're asking me if I adopt his recommendation and his ultimate rates that he sponsors, I do not.
Right. Thank you. That's all I have, Your Honor.
Okay, thank you, Mr. Curran.
Good afternoon, Mr. Valcarengi.
Good afternoon.
William Fields for the Office of People's Counsel. Before I get into depreciation, I have a few questions, TCJA-related questions, and they start, if I could refer you to page 4 of your direct testimony.
Okay.
But this is where you start your discussion of TCJA.
Tax Cut and Jobs Act.
Yes. And then if you could turn to page 6 at the bottom, you talk about PE's, this is a question and answer at the bottom on page 6. You talk about the PE's compliance filing, and in the sentence, and this is talking about the refund reflects the accrued regulatory liability consistent with compliance with the TCJA and includes carrying charges. And then on the sentence that starts on 6 and goes over to 7, you say staff has reviewed PE's calculation and its accrued regulatory liability and continue to find the approach reasonable. You see that?
I do.
Okay, now if we could turn back a little bit to page 5. This is now in your discussion of TCJA. The answer that's at the top of page 5 you are referring back to Mr. Valdez's testimony, correct?
Yes.
Okay. And and I believe the numbers that you have there come from his schedule REV1.
I believe that's correct.
Okay. I have some copies of REV1 just for everybody's convenience. I can pass those out if you don't have it in front of you.
For Mr. Valdez's, I do not have that with me. Thank you.
Okay, so Exhibit REV1. Could you just describe what this exhibit, what the calculation this exhibit is showing?
Exhibit REV-1 from Mr. Valdez's testimony is a calculation to reflect the impact of changing the corporate federal income tax rate from 35% to 21%.
All right, and and down in line 26, we see those two percentages, correct?
We do.
And line 27, we have the different amounts for federal income tax calculated at 35% and at 21%. Is that right?
Yes.
Now, does this chart, does this schedule include deferred income taxes?
I take this schedule to mean that it is solely related to the movement in the corporate tax rate. In other words, it's the income effect.
But to your knowledge, are there any deferred income taxes shown in this schedule?
Are you asking me whether it reflects an amortization of the excess deferred income taxes?
Well, that would be one possibility.
I do not see deferred income taxes on this schedule.
Okay.
No.
And okay. Would deferred income taxes get the same treatment between the 35% calculation and the 21% calculation as shown on this schedule?
No.
You don't think so? Okay.
Well, there's a different methodology for calculating. You're not going to go through an income statement and derive the impact. There are certain categories of excess deferred income taxes, be it protected or non-protected. You determine them and then you amortize them over a specific period of time. Typically, those that are related to depreciation or amortized consistent with ARAM.
And would those then show up like in line 7 where it says amortization of excess ADITs? Which says 0 on this schedule?
Possibly.
If they were there, then it would appear from this schedule that in the left-hand column, they would flow down and be multiplied by 35%, and in the right-hand column, they would flow down and be multiplied by 21%. Isn't that right?
I'm not sure. I didn't look at it from that perspective, so it's difficult as I sit here to sit here and make that leap.
Okay, fair enough. Let's turn to your sur rebuttal, page 3 and 4, where you do talk about your recommendation on depreciation.
Page 3 and 4.
Yes, I believe so.
Okay.
And you say there that the test year, this is in line 8, test year depreciation expense is $34.6 million. It's your understanding that the company is proposing to include that amount in the rates that come out of this proceeding, correct?
34.6 is book depreciation in the test year. So yes, it would be included in the development of the revenue requirement.
Right. Okay. Now, your recommendation is for the company to file a depreciation study within a year, and I guess my question is, what would happen then?
And is that a question?
Yes, yes.
A number of things could happen. I mean, certainly they would file with the commission. We could have another case. We could have a phase 2. I mean, once the study is filed, there are a number of avenues that the commission could entertain that study if it so chose.
Okay. So I think we expect the order in this case in March.
March the 22nd, if I remember.
Okay. And so if the commission orders them to file a study, they would file that in a year, if the commission orders them to file it in a year, they would file it in March of 2020, correct?
Give or take a few, yes.
Give or take. And then you're saying that at that point there could very well be litigation that would then proceed after that.
Well, certainly once the depreciation study is here, it would have to be analyzed, reviewed, and parties would have to, I would assume, litigate the result and determine what the reasonable outcome of the depreciation study would be.
So, in the meantime, then customers would continue paying the $34.6 million a year through their rates for depreciation, correct?
Well, yeah, absent an order from the commission, what's in place is considered reasonable.
Okay. Now, you have reviewed Mr. Guerin's direct testimony, correct?
I did.
And you are familiar with the commission cases he talks about with regarding the present value method or SFAS 143 method, is that right?
I can't recall the specific cases that he cites in his testimony, but I am familiar with the SFAS 143 methodology.
Okay. And are you familiar with, and is it your understanding that the commission, in adopting the present value method has talked about finding a proper balance between what current or maybe near future ratepayers are paying and the cost responsibility of ratepayers further out in the future. Is that your understanding?
Well, that was the historic, I guess, the commission's historic narrative was it was designed to give value between current customers and future customers. So you did this, you do this discounting in order to achieve that value.
Right. A discounting which is not reflected in the 34.6 number, correct?
Well, it's not, but it's the rates are based on those rates that were deemed reasonable the last time they were reviewed by the commission.
Which did not incorporate the PV or SFAS 143 method, correct?
PE's current rates do not reflect the SFAS 143 methodology. No.
Okay. So, if the commission accepts your recommendation and customers continue to pay rates reflecting $34 million of depreciation expense for a year plus however long after that those rates would stay in effect, then the rates for that period of time would not reflect the balancing of cost responsibility that the commission was discussing with respect to the PV method for that period of time, correct?
Well, there couple things. I think you ultimately assume that the depreciation study that will be filed in the future automatically assumes a reduction in line with what OPC witness Guerin suggests. We have no idea what the ultimate impact of a study would suggest. And while the commission has used the present value method in the past, we don't know what the future will tell. Maybe the commission will use that method in the future. Maybe they won't. It is the preferred method that has been utilized in the past, but just like everything else in rate making, things change, or things have the possibility of changing.
There's no commission orders that indicate a change to that approach, are there?
I'm simply giving you my opinion as to what could happen. You're looking at the number and saying or intimating that customers are necessarily overpaying now, and I'm saying, well, that may not be the case, because number one, we don't know what the depreciation study is going to result in, and we don't know what methodology will come out from the study. Right now, today, we know the past cases from the commission have relied on the present value. The commission could adopt that moving forward, and they may not.
Okay. Now, what we have in this record, the only evidence we have in this record looking at the service, calculating service lives, reasonable service lives based on recent PE Maryland data is Mr. Guerin's analysis, correct?
Well, Mr. Guerin did an analysis, yes.
Okay. And that's the only analysis we have that deals with recent PE Maryland data, correct? To estimate service lives.
Mr. Guerin's analysis is the only testimony in the record which reflects alternate lives, if that's
okay.
That answers your question.
My question is more that's the only testimony that estimates those lives based on recent PE Maryland data, correct?
Well, yes, that's true, but I mean, if you're asking me whether I adopt the analysis that Mr. Guerin did, my answer would be no.
No, well, I wasn't asking you that, but I think you answered the question. Your surrebuttal, you do not have any, provide us any specific disputes you have with Mr. Guerin's analysis. Isn't that correct?
I did not articulate that in the testimony, no.
Okay, thank you. I have no further questions.
Thank you, Mr. Fields. Mr. Dean?
Briefly, Your Honor. Mr. Valcarengi, in the Office of People's Counsel questioning of you, you were asked whether or not you accepted Mr. Guerin's depreciation analysis.
I don't know what specific words he used. I mean, I recognize that Mr. Guerin proposed alternate rates, and if the question is, do I adopt those rates, the answer would be no.
I believe that the question you were asked was phrased as whether or not the study was based on Maryland data. Do you believe that Mr. Guerin's analysis is based on Maryland data?
It was information that was provided by Potomac, Edison, and Discovery, so I have no reason to suggest it's not based on Maryland data.
Okay, thank you. Staff has no further questions.
Thank you very much, Mr. Dean. Good afternoon, Mr. Valcarengi.
Good afternoon.
Thank you for your testimony. Mr. Valcarengi, Mr. Valdez, I believe in surrebuttal, tried to address your pension and OPEB concern with double counting. I believe it was page 12 of his testimony. Do you continue to have a concern, or are your concerns addressed?
I think I'm still concerned with the shift in the methodology. I don't think the company has put forward sufficient documentation that maps out the movement between where they were when they were on the alternate methodology to the methodology that we have now.
Okay. So your concerns remain the same. Okay, thank you. Mr. Valdez also attempted to address your concern with normalization violation on page 20. Do you continue to have a concern with respect to that?
No, I don't have a concern. I simply noted that as an exercise of caution. If the company believes it's not a normalization violation, then I don't have a problem with it.
Okay, thank you. So I'm going to follow up a little bit on what Mr. Fields was asking you about what next on page 15 of your direct testimony. You recommended that PE be directed to perform a depreciation study. So in the what next, do you recommend that how would the new depreciation rates be? How would the results of the depreciation study be incorporated into rates, in your view?
Well, you could do one of two things. You could do a phase 2 to this case here, or you could implement another rate case. I heard you talking yesterday about how long it would take to do another rate case and do a depreciation study, and I think Mr. Valdez indicated it would be roughly 24 months. The problem as I sit here is, although you have Mr. Guerin's testimony before you that has a quite a large difference, it's difficult to know what the ultimate impact is going to be. Certainly, a phase two, if it's a large impact and have a retro back, is one thing that the commission can implement. That way, if there is a large disparity, as People's Council suggests, then customers are not overburdened. But it's difficult to sit here and kind of give an impact to that, because we don't know what the impact is going to be. I mean, certainly, People's Council suggests it's a 48% reduction in depreciation expense, but part of that I think has to do with some of the lives that are suggested in the analysis. And you could either do a phase two or you could do another case.
Okay. Mr. Efron is proposing a capital repairs deduction. Are you familiar with that?
I saw his testimony on that.
Right.
I've read his testimony. I don't think I can respond effectively to that point. I understand it. I don't have any other information that I guess I could offer you.
Is that a deduction that the commission has adopted in the past?
Well, it would be a standard item that the company would reflect in the development of deferred taxes.
Okay.
And I guess if I take Mr. Valdez's point, is that they simply didn't have any information. That's why they didn't do it. And I guess the follow-up, Mr. Efron says, okay, well, if you don't have any information, do this 5-year average, is I think what he did.
Right.
As I sit here, what Mr. Efron did, it doesn't bring me pause. I mean, it would be unusual that it would be zero, in other words.
Would it be unusual for it to be 26.4%?
I don't know the history well enough to say whether it should be 26 or 50 or 17.
Right.
But providing an average kind of gives you that, I guess, stability over that period, that it's not high and it's not low.
Okay, thank you. You seem to be concerned with the smoothing effect that the company is proposing, and Mr. Efron seems to, having had sufficient information, I believe Mr. Efron seems to agree with it. And do you continue to disagree with the smoothing effect?
Yeah, and that's what I was kind of talking about earlier. I think I kind of jumbled my response to your earlier question. That he's right about, Mr. Valdez was right about the direct assignment question. But the ultimate thing is there sufficient documentation and narrative which explains how you go from back in the day to now. My answer is no. I mean, I have a worksheet that says, well, here's the cost, but there's nothing out there that says, well, how did you get there? You know, is it this, is it this, is it this, is it this? We simply don't have that.
Okay. So one more question with respect to the the refund. I'm a little confused with the dates. Are you proposing a refund of the an additional refund from the prior amount that has already been refunded? I'm not talking about the I believe was it from October till March. I'm talking about the January through October. I'm a little confused about the time periods.
The first refund was based on your directive, and it encompassed the period January through the end of September, and that was roughly, I don't know, 4.8
Right.
4.8 million. I went and I recalculated that because I didn't like, I took exception to the smoothing adjustment. And then I went back and I said, well, their way of developing carrying charges, I didn't agree with that. And I said, you should be compounding that, the interest.
So did you raise that when the commission reviewed the number? I believe the commission reviewed that number in a administrative meeting, I believe.
I don't think it, I think you ordered, we provided comments to the commission, and then the commission said, I think PE's position was, no, don't do anything, and our position was you need to refund those dollars. And I think at that point you said refund the dollars, but there wasn't a narrative as to how you get there.
So there wasn't a review, because we had a lot of these, so I'm, not completely sure which ones where we were, but I'm just trying to, you believe we didn't look at the number. We just said do
That's
the refund.
correct.
Okay, and so now you're looking at the number, and this is the impact of the number.
That's right.
And then there's with respect to the October through March, there's also a proposed change.
Yes.
Right. Okay. Thank you. I appreciate that clarification. Commissioner Richard?
Good afternoon.
Good afternoon.
Just a couple of questions. I was interested in just the overall staff rationale on the EDIS program and the fact that you are recommending it is okay. You think it's to deviate from traditional rate making principles and consider a surcharge. I'd just like to understand a little more about that. When we look at the surcharges that BGE and PEPCO, the DRI, I think it's GRIs, the context of those were in a time when our state policymakers were very up in arms that they had been some really almost crisis level poor performance, and so these surcharges were really to help accelerate to achieve at least an acceptable level of performance. In this case, well, it's arguably a really good proposal. The question I would have is, does it merit a surcharge? I mean, we have a company that actually is doing, in their own words, I believe it was exemplary, and have achieved and appear to be able to continue to achieve the minimal, obviously not minimal, but the high level performance standards metrics that the state has set. So can you just help me understand then the rationale? Why deviate from traditional rate making principles?
That's a good question. I think my response would be, we looked at it as a staff approach. I think my engineering colleagues reviewed the programs, and then based on the commission's decision with respect to BG&E, from our perspective, it was something that fit nicely with what is proposed here. Now, I can't comment on where PE is in terms of their performance. Are they above, below, or what have you? I think Mr. Lowe can speak more intelligently to those kinds of questions.
Okay. I just brought it up since it was in your testimony. Again, I guess we don't completely pile on this whole depreciation study issue, but I do note that in I think it's page 14 of your direct, you do talk about the generally every 3 to 5 years a study should perform. That correct? And obviously that helps us make sure we get the depreciation expense right, and therefore set just and reasonable rates. Is any other reasons you can think of why we would want to get that right? Or are those basically?
Well, there's multiple reasons. I mean, it affects the expense, and it affects deferred taxes. But ultimately, it's how you're recovering your assets. It's how quick or how slow.
Right.
So generally, you want to be in a position where you're reviewing them 3 to 5 years. Does that mean you're going to file a study every 3 to 5 years? It all depends on what the impact is going to be. That would be my opinion.
Okay. And then there were questions asked about, okay, so your recommendation, we do this, direct the company to do this study within a year. And then we asked Mr. Fields and Commissioner Herman, then really what? And it kind of goes to, where does the staff feel that we are in urgency? And with that, I would, kind of point out with Mr. Valdez's in a testimony, he has the chart where he talks about how, they performed, they considered this a litmus test by looking at depreciation studies that were done by with that other utility,
Monongahela Power.
I can never say, or West Virginia PE. Within approximately the 3 to 5 years, if I'm reading the testimony correctly, they did do a depreciation study, and when you compare their existing bars, and it's on page 5 of the rebuttal, the chart I'm looking at, and there's some narratives that go
Mr.
on
Valdez.
before that. Yeah. But it appears that in both cases, when the depreciation study is done, there is a decrease in depreciation expense. And again, that was from studies that were done within the 3 to 5, approximately 3 to 5, may have been just slightly over 5 years. So in contemporary studies, it appears that we would likely see, if a study had been done, a similar decrease. And then you also point out in your testimony the additional advantage is the fact that we likely would want it to include the SFAS 143 methodology, which would also likely decrease that. So, on this urgency, is what would you recommend? I mean, is this a pretty critical to us in setting these expense rates and thus just reasonable rates? And these depreciation rates, I mean.
How critical is it? I mean, it's always critical to have vibrant, reasonable depreciation rates. Mm-hmm. Do I believe that the rates in place are so out of flux that you need to do something and you need to do it like now? I went through and I compared the parameters account by account by account to all the utilities, or many of the utilities in the state. And I'm not talking about the depreciation rate. I'm talking about the parameters, the lives, and it's not like you see outliers. They're generally in line with utilities that are here in the state.
Okay.
So, but once you parlay that into your net balance, your plant less your reserve,
it could have a difference, but the lives, the parameters, I don't see drastic differences right now.
Okay, drastic, but I think you agreed that from the testimony of Mr. Raymond Valdez, when you look at those contemporary studies, depreciation studies, there was a decrease in depreciation expenses from the existing.
Yes.
So obviously, in similar utilities, and they were characterized as similar utilities, there was a decrease.
Yes.
And then, in addition, if I'm hearing you correctly, there would likely be also a decrease if we applied the SFAS
If
143 methodology.
if you applied an SFAS 143, there would be a reduction in PE's depreciation expense. I have no doubt about that.
Okay.
But the point that needs to be made, Mr. Valdez did analysis, and it showed using PE West Virginia rates, there was a $2.7 million reduction.
Right.
Using Delmarva's rates, it was roughly, I think, 1.5 million. The Delmarva rate would include the SFAS 143. I believe the rates from the West Virginia study would not. So that kind of gives you a range as to what kind of impact we're talking about.
Yeah, my only inference is, really, I didn't really fully understand how we would judge Delmarva, why that was used as an example, because
Well-
I don't know the how the two utilities relate to each other. But I
Well,
did note the difference between when they study, and a comparison was done between pre-existing rates, and after the study was done between the two West Virginia utilities, there was a decrease. So, to me, that was, I think, the important point to be taken from that. So, again, we don't have to get into the Delmarva unless you.
Well, I think Mr. Valdez, and I think he used Delmarva because it was one of the only electric utilities that had filed approved rates over the last five or so years that weren't in a settlement.
Mm-hmm. Okay, but it was never characterized. Was there a similarity between? That there was a similarity between Delmarva and PE. So
Well,
it was between the West Virginia utilities and PE Maryland. Is that correct?
Yes, they're one and the same.
Okay. Great. Thank you.
Mr. Valcarengi, I don't have much for you because I've reviewed your testimonies and I'm hungry. So, just two quick questions. You recommend that or you maintain that a depreciation study should be done every 3 to 5 years. What's the basis for that periodicity?
It's typically, it's kind of like a rule of thumb. It's not in a book or manual. It's kind of like a guideline that I would say the industry follows.
Why not 5 to 7? Why not 1 to 4? I'm trying to understand why 3 to 5.
Once you go outside 5 to 7, then you're looking at, well, is it stale? Is it dated? 3 to 5 years is more of it gets back to current operations, I would say. And once you get longer than, 5 to 7 years, then you go, well, why is it taking so long?
Is it still relevant? I got it. Okay, thank you. The other question I had regards your recommendation to approve the EDIS. Did staff take into account when arriving at this position the fact that if we were to approve this, that once we do, some of these are long-lived. One aspect is 23 years, and vegetation management is going to be going on in perpetuity. We will have the authority, of course, to stop this should we believe it's in the state's interest. But by practical effect, once we approve this, it's going to be very difficult, absent some good cause, to ever do away with. Did staff take that into account in their recommendation?
We didn't take it as a mechanism that would be in perpetuity. I mean, I can tell you, BG&E has a similar mechanism that sunsets, I think, after, I don't know, 2018 or 2019, and it sunsets. Our recommendation was that the EDIS sunset after a specific point in time.
What is that sunset, your recommendation?
I thought it was 5 years.
Okay, I wasn't sure, because I thought I saw 2022, but I wasn't sure that was the sunset you were recommending.
Yeah,
Three-year window. Maybe it's, you say on page 21, authorize PE to recover reliability investments in a surcharge operative for a period 2019 through 2022 with sunset provision. Is that the sunset date, 2022?
Yes.
Okay. All right, very good, thank you. That's all I have.
Thank you for your testimony, Mr. Valcarindi. We will recess now for a lunch break. We'll return at 10 of 2. Thank you. Let's go back on the record. Mr. Spivak, you'd like to call your next witness?
Yes, thank you, Your Honor. The commission staff calls Yulia Poboreski to the stand, please.
Sorry, Mike.
Please, sir, in confidence with Mr. Perkins, that the testimony you have to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Good afternoon, Ms. Poboreski.
Good afternoon.
Do you have in front of you a document captioned in Case 9490 entitled Direct Testimony and Exhibits of Yulia Poboreski on behalf of the staff of the Public Service Commission of Maryland and dated November 20th, 2018?
I do.
Does the document consist of 18 pages of question and answer testimony, and I believe it is one attachment and 16 exhibits? 15 exhibits, excuse me.
15. Yep.
Did you prepare this document, or was it prepared under your direct supervision?
I prepared it.
Do you have any additions, deletions, or other corrections you would like to make at this time?
I do not.
And do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Ms. Poboreski's testimony direct testimony be marked as Staff Exhibit 13.
So marked.
Ms. Poboreski, do you also have in front of you a document also captioned in Case 9490 entitled Surrebuttal Testimony and Exhibits of Yulia Poboreski on behalf of the staff of the Public Service Commission of Maryland, dated January 16th, 2019,
I do.
consisting of 4 pages of question and answer testimony and, again, 15 exhibits?
That's correct.
Did you prepare this document, or was it prepared under your direct supervision?
I prepared it.
Okay. And do you have any additions, deletions, or other corrections you would like to make at this time?
I do not.
If the questions were asked of you today as they're asked in this document, would your answers be the same?
Yes,
And do you adopt this document as part of your sworn testimony?
I do.
Your Honor, staff requests that Ms. Poboreski's surrebuttal testimony be marked as Staff Exhibit 14, please.
So marked.
Now, do you also have in front of you a document that was filed behind a cover letter on January 22nd, 2019, consisting of updates to a number of your exhibits?
I have it in front of me, yes.
Okay. And how many of the exhibits were updated, please?
I believe it's 7.
7 of the exhibits. And did you prepare these updates?
Yes, I did.
And what was the reason for doing so?
On Wednesday, January 16, we received an updated revenue requirement by Potomac Edison. So my exhibits are revised based on this information that was provided that day.
Okay, thank you. And do you have any additions, deletions, or other corrections you want to make on this document?
Not to this document. From what I heard this morning, there will be some additional corrections by PE. I assume that my exhibits will have to be revised based on the information that will be provided after the staff will get a chance to review it.
Okay, thank you. All right, Your Honor, staff requests, Ms. Poboreski, do you adopt these revised exhibits as part of your sworn testimony?
Yes, I do.
And staff requests that they be marked as Staff Exhibit 15, please.
So marked.
And finally, Ms. Poboreski, do you have in front of you a copy of the comparison chart filed by staff also on January 22nd?
Yes, I have it.
And did you prepare this document with assistance from the other parties?
Yes.
Okay. Do you have any additions, deletions, or other corrections you want to make to it at this time?
Not at this time.
Okay. Do you adopt this document as part of your sworn testimony in this proceeding?
Yes. Please note again that the numbers on the chart might still be revised there. Corrections proposed by PE.
Okay. Thank you. Staff requests that the comparison chart be marked as Staff Exhibit 16, please.
So marked.
Staff further moves that Staff Exhibits 13 through 16 be admitted to the evidentiary record.
No objection.
Seeing no objections, they are admitted.
And the witnesses available for cross-examination.
Thank you very much. Mr. Trout? Mr. Curran?
Thank you, Your Honor. Good afternoon, Ms. Poboreski.
Good afternoon.
There are three topics that I'd like to ask a few questions about concerning each topic. The three topics are storm expense, outside counsel, rate case expense, and then employee compensation expense.
Employee activity cost or
No,
compensation?
compensation paid
Incentive?
to the employees. Yes, the incentive primarily, incentive pay. Those are the three topics. Let's take them one at a time if we could. With respect to the storm expense, could you turn to page 10 of your direct testimony?
I'm there.
And on page 10, am I right in understanding that you explain that when you reviewed the company's calculation, which was based on a 5-year average, you concluded that one of the 5 years, that the year ending June 30th, 2014, should be excluded, and further that you based your judgment that it should be excluded on your conclusion that it was, and I believe I've got your exact words here, extraordinarily high, is how you characterized it in one place here, and an outlier is the other way you characterized it.
That's correct.
Okay, good. You would agree, however, that those storm expenses were actually incurred during the period that ended June 30th, 2014.
I would agree with that, yes.
And you would also agree that, and I believe it's correct, that you responded to a data request in which you said you had no basis for believing that any of those storm expenses were imprudently incurred.
That's right.
So as far as you know, they were all not only actually incurred, but prudently incurred.
I believe so.
Thank you. In the analysis that you conducted of the storm expense, which you describe here on page 10, you did not exclude any years of the 5 years on the grounds that they were too low, did you?
No.
Okay. And in fact, there was 1 year where the storm expense was quite low. Isn't that true?
That's correct.
For the period ending June 30th, 2017, the storm expense was just over $500,000 for the entire 12-month period. Okay. And that's very low compared to all the other years in that 5-year period.
That's true.
Okay. But you didn't exclude that.
If you would like, I can explain how I came up with my judgment for this adjustment.
I would certainly not want to obstruct you from giving that explanation, so please go ahead.
Okay. When I looked at the adjustment number 4, presented by PE, where PE does make this average over 5 years. 2014 did look that the number is extremely high. It 9.5 million. To compare it to the highest for the following years, it's about 3 million. So when I recalculated, I did the 4-year average, I did 3-year average, I did 2-year average, and I did exclude the highest and the lowest. And still, all those averages were so much lower than what the company proposed. If you want to compare, the 4-year average was about 2 million. The 3-year average, like about 1.3 million, 1.5 million. So that's why by giving the company 2.4 million, which is a test year expense, I believe that it's higher than all other averages, slightly, but still comparable, but not as much as 3.4 million that the company proposes. That was my judgment in that.
I understand. I just want to get one thing clear in my own mind and hopefully on the record. So when you discussed the various different averages you determined, you didn't actually have to do the 5-year again because that was the company's number.
That's correct.
Okay, good. Now, did you review Mr. Adams's rebuttal testimony on this same subject matter?
Yes.
Okay. And do you recall that on, would you accept subject to check that on page 5 of Mr. Adams's rebuttal testimony, he points to 10 years of storm data?
I have seen it.
Okay. And he suggests that if you look at 10 years of storm data, then the 2014 number is not an outlier, that there are several other years that had high storm costs during that 10-year period.
That's correct. The average of 10 years was about 4 million.
Okay. So the average of 10 years was actually higher than the 5-year average number proposed by the company.
That's true.
Okay. So the company chose a shorter period, even though it resulted in a lower recovery for the company.
It seems that way, yes.
Thank you. We can move on now to the second topic, which was outside counsel expense. And we're still in your direct, and now I believe we're on page 13.
Can I add something regarding the storm expenses still?
If the commission allows, I'd certainly not object.
Staff proposed this specific adjustment to take the test year expense in conjunction with the other suggestion if the company is concerned for under recovery of storm expenses. Staff did support PE's proposal for deferral regulatory asset or liability for the storm expenses. Therefore, I believe that should take care of the company's concern if they under-collect in the test year. So basically, these two, staff's adjustment and the proposed deferred treatment, come together for the storm expense, just to complete the record on that.
Thank you. All right, shall we move on now to the second topic?
Yes, please.
Okay. So we're on page 13 of your direct testimony, and there you propose that in connection with the determination of an appropriate level of rate case expense, that the fees that the company would be allowed to pay outside counsel and then recover as part of that rate case expense be capped at $300 an hour.
Correct, recovered.
Okay. All right. So you would agree, wouldn't you, that the company is entitled to hire counsel that's experienced in practice before the commission?
I do not judge the company's choices, but it seems that you're doing a great job so far.
Just to make the record clear, I'm unfortunately in-house counsel, so I don't get paid. I don't get paid $300 an hour, let alone more than that. But yes, Mr. Curran and his firm are doing a great job. I would agree with you. Thank you. I'm actually a little in all of that. I lost track of what your actual answer was. So, did you say that the company is entitled to hire counsel that's experienced in practice before this commission?
Again, it's not my choice what the company chooses. I believe that the recovery should be limited, and the staff would never object to anything that the company do as far as like hiring whoever they seem appropriate.
Okay.
But the recovery through the Maryland ratepayers, my belief is should be somewhat, and I do believe that it's generous as in this case staff follows commission's precedent in case 9316, which was Columbia case, and that was decided by the law judge in this case. Therefore,
who's sitting right over there?
Right,
yeah.
Ms. Romine.
Yes.
But it was staff proposal originally, and the judge has agreed with staff that it's pretty generous recovery of the cost per hour for the outside legal.
Well, you would agree with me that Judge Romine made her proposed order, so therefore proposed that cap in 2013.
That's correct.
And we're sitting here in 2019. Were you present when Mr. Valcarengi was testifying late this morning?
Yes.
Okay, and you heard Mr. Valcarengi say that one of the constants in rate making is that things change.
With that being said, I believe in that Columbia case, the recovery per hour, though I know it's confidential information in this case, but it was very much similar to what is being per hour charged in this case. So I don't think the information changed all that much for outside charge.
Okay.
Outside legal fees per hour.
Thank you. That was very helpful, and I want to see if there's a way we can build on that a little bit without disclosing any confidential information. So, it's not, I don't think, in the record in the Columbia Gas case that you're referring to what the actual outside counsel fees were in that case, of which only a portion were recovered, and it's not in the record in this case, in the evidentiary record, we've provided under seal in a data request response our contract with Mr. Curran's firm to staff and OPC. Did you just say that you or folks working under your direction looked at what the actual rate was in the Columbia Gas case, and you looked at what Venable's rates are in this case, and they are comparable?
I believe so.
Okay. Okay. I want to circle back to the issue of who it's appropriate to have as an outside counsel in a base rate case in a Maryland Public Service Commission proceeding. Would you agree generally with the proposition that the commission benefits from having attorneys presenting a case before them who know what they're doing and part of knowing what they're doing would be they've been in front of this commission on a regular basis before.
Absolutely.
Okay, good. And would you also agree with the proposition, based on your, did you say it was 7 years? 7 years of work here with the commission. Would you agree that there is a limited number of attorneys and even of firms that appear on a regular basis in front of this commission?
What do you mean by limited number?
Maybe a better way to put it would be, you see the same lawyers, the same relatively small group of lawyers. There's a dozen or so of us who are in front of this commission all the time, and that's it basically. It's a small it's a small bar, if you know what I mean by bar.
I can agree with that.
Okay. And you don't dispute that the rates that the company has requested as a basis for this portion of its rate case expense are in fact the rates that we are being charged.
I have no doubt.
You have no doubt that we've
This is
asked
a
for
charge.
the correct number.
Right.
Thank you. Okay. And would it be fair to assume that you have not participated in the retention of outside counsel to appear on behalf of staff in either before the commissioner or in some other proceedings, perhaps through staff issuing an RFP for outside counsel work or directly hiring a law firm? You've not been involved in doing that.
No, we rely on our staff.
Okay. So you don't have any evidence that, well, maybe I can ask this even more directly. You're not asserting that the fees that the company's being charged are excessive, are you?
It's not what I'm saying. What I'm saying is that the recovery should be limited.
Okay, good. All right, good. Thank you. Okay, good. And so, by extension, since they're not excessive, they're not imprudent.
I'm not gonna say that they are imprudent.
Okay, good. Fair enough. Thank you. I think that's all I have on that subject. Let's move to the last one, which is the compensation paid to the company's employees. And we're still on your direct, and we're on pages 14 through 15. And it's the portion, I'm not going to ask you questions about the employee activities cost. Absolutely, we're not going to go there.
Okay.
But right after that, on line 16, there's a discussion of PE's incentive compensation. You see that?
I do see it.
Okay. And that discussion continues through page 15, line 19. Is that right?
Yes.
Okay. And so you're proposing that a portion of the costs relating to the S-tip and the L-tip be excluded, right?
The portion related to financial goals of the
Okay.
goals of the company.
All right.
Yes.
Got it. And then, with respect to the SERP, was it a portion or was it all of it?
I believe the company removed portion of it, and we removed 100%. Basically, it's a removal of 100% of SERP from cost of service, right?
Okay. So it's a partial reduction or partial disallowance with respect to the S-tip and the L-tip, and it's a 100% disallowance of the SERP expense.
Correct.
Okay, good. Thank you. And it's not your position on behalf of staff that any of the expense that the company submitted with respect to those topics was not actually incurred, correct?
I do not suggest that.
Okay, good. And you're not contending, are you, that the company would be able to hire and retain employees at less than market rates of compensation, are you?
I'm not judging that. I have no opinion on what the company hires.
Okay. I believe I am done, Your Honor. Thank you very much, Ms. Poboreski.
Welcome.
Thank you, Mr. Trout. Mr. Cleaver?
Yes, thank you, Your Honor. Good afternoon, Ms. Poboreski.
Good afternoon.
I'm Joe Cleaver, as you know, Office of People's Counsel.
Hi, Joe.
Nice to see you. If I could start by referring you to your revised exhibits, which have been marked and admitted as Staff Exhibit 15.
Okay, I'm here.
Could you take a look at, it says Surrebuttal Exhibit YP12 revised.
Could we go off the record for just a minute? I
Yes.
need to ask Mr. Spivak for a copy.
We'll go off the record just a moment.
I'm sorry, Joe.
I actually I have copies because I...
Oh, okay.
Are
Do
we-
you want to
Sure.
give me a copy? I don't care where I get it from. Thank you very much.
Okay,
Thank you, Your Honor.
back on the record?
Your Honor, actually, could I approach at this point with two exhibits?
Yes.
Thank you.
Thank you.
What you got to?
Thank you.
Your Honor, I've handed the witness two exhibits. The first one is a page of the company's update for actuals. Title at the top is Section 2E Actuals, Attachment 3, page 1. I would ask that that be marked as OPC Exhibit 14.
Yes. So marked.
Thank you. And the next item is the company's response to OPC Data Request 913 with an attachment. And I would ask that that be marked as OPC Exhibit 15.
So marked.
Thank you. Okay, so Ms. Poboreski, are you at Surrebuttal Exhibit YP12 revised that I asked you to turn to a couple minutes ago? Are you there?
Yes.
Okay. And if you look at line 1 there, you see it says AFUDC for test period ended June 30th, 2018. And the amount that's listed there is $279,689. Do you see that?
That's correct.
Okay.
Yeah.
And can you turn to what I handed you? I've asked to be marked as OPC Exhibit 14. And this is, as I mentioned, it's a page from the company's update, Section 2E Actuals, Attachment 3, Page 1. And if you go back for a moment to Surrebuttal Exhibit YP12 Revised, you can see down in the key under Notes that the item, the number 1 in parentheses, which appears next to that AFUDC line, it states per PE Supplemental Data Section 2E Actuals Attachment 3, Page 1 of 1. So now turning back to what's been marked as OPC Exhibit 14, is this the document that you're referring to there?
Yes.
Okay. Now, if you take a look at this document, that number that appears in your schedule, the 279,689, that number appears, of all these numbers on OPC Exhibit 14, that number appears at the bottom right, correct?
Correct.
And that's where that came from?
Yes.
But this figure that appears here is actually, that's just the figure for June 2018, correct?
It is possible that you are correct on that one. I assume that it's cumulative but it does look like a June 2018 number.
Right.
Now when I look at it.
Okay, and just to confirm that, if I could refer you to what's been marked as OPC Exhibit 15, which is the company's response to OPC Data Request 913. If you turn to attachment, well, let me back up. That request asks the company to please reconcile the AFUDC income on Exhibit JLA1, Column 2, to the ADUDC income on Filing Requirement, Section 2E, Attachment 3, Page 1. Do you see that?
I do.
And if you look at the attachment in the AFUDC column and you follow it across, you can see that these are the numbers for each month that appear on OPC Exhibit 14, which is the page of the company's actual update. Do you see that?
Yes.
Okay. And if you look over in the far right column on Attachment A to OPC Exhibit 15, you see that the total amount there, that the cumulative amount is actually $2.8 million. Do you see that?
I see that. What's interesting is that I asked the question about AFUDC because it seemed to me somehow off. So our DR 42 that we got responses only today refers me to OPC 9-13.
Okay.
So I did have in mind that there might be something off.
Okay. That's a correction that'll need to be made to your exhibits.
I would agree with that.
Okay. And as you sit on the witness stand, are you able to provide any kind of ballpark or back of the envelope estimate as to the effect that would have on your recommended revenue requirement?
I'd rather do it on a computer and then present the number.
Okay. Thank you. Fair enough. Could you, sticking with your revised surrebuttal exhibits that have been marked as Staff Exhibit 15 and entered, could you turn to the next exhibit, which is YP13?
I'm here.
And I'd like to ask you about line 4.
Okay.
And there you there's an item described as total PE's allocated interest on debt. Do you see that?
Yes.
And then the amount is $10,712,899.
Mm-hmm.
And There's also a signifying symbol, so to speak, there, a 3 in parentheses. And if you look down in the notes column, you can see that that means that that number came from PE's exhibit number JLA 318, actual revised.
That's correct.
Okay. Now, are you aware that this number changed as a result of the company's January 16th filing, the response to 4015, but that it didn't change from your original surrebuttal exhibits to this exhibit?
I actually changed that.
You did change this particular, let me take a look.
Right.
Well, if I could ask you to turn to your surrebuttal testimony.
Surrebuttal testimony. Are you talking about surrebuttal testimony or revised surrebuttal exhibits?
The original surrebuttal testimony. Could you turn there? And could you turn to your original surrebuttal exhibit YP13?
Was your question whether I changed it in? Okay, let's do it one by one. Okay, you can ask your question.
Okay, so if you could look side by side at your original surrebuttal exhibit YP13 and then the revised surrebuttal exhibit YP13, the number on line 4 doesn't change, correct?
I can explain that. We received the actual exhibits as a response to 40-15 on January 16 at 2 p.m. and staff decided to incorporate the majority, to present the commission with most actual and updated information. Staff decided to take the exhibits and to the best of our ability in a few hours that we had to update the numbers. So basically that's why you see the number has changed from direct, because in my surrebuttal I already included the company's actual information. The revised exhibits provide updates that came to our knowledge after we filed surrebuttal. But at surrebuttal I already updated for company's 40 or staff DR 40-15.
I see. So your surrebuttal incorporated some of the changes from 4015, but those changes that were not captured are reflected in your revised surrebuttal exhibits.
That's correct.
Okay. And could you explain how you derived this number of 10,712,899?
My exhibits present adjustments to companies' adjusted numbers. So if you will look in the formula for Excel spreadsheet that we provided together with the exhibits, you'll see that I'm incorporating the 9.4 million that you have here on actual, and I make my adjustment as staff's adjustment to that actual number provided by PE. That's how we come up with our flow through and other adjustments for revenue requirement.
Okay, so just so I'm clear, so this $10 million 712 figure, that figure includes an adjustment already within it. Is that
It
right?
includes the actual company's number as presented on 40-15 that provided on January 16, and on top of it we have our adjustment to it to come up with the adjustment for PE.
Okay.
Basically, we adjust the actual number of PE to come up with staff's recommendation.
Okay. All right. Thank you. Ms. Poboreski, did you, were you here or were you listening to the questions that I asked Mr. Adams about a company response to a staff data request 40-14 44 that concerned a land purchase in December 2018?
I was listening from my office, yes.
Okay.
I remember that conversation.
And did you also hear Commissioner Herman issue a bench data request following up on that response?
Yes.
Okay. If, once that response to Commissioner Herman's bench data request is produced, if it's revealed that the land in question is not in service, would staff make an adjustment to its allowance of post-test year terminal safety and reliability spend?
Yes, we will.
Okay. And if it's revealed that that land is not in service, would staff undertake any other investigation into whether any other of the plant that's included in the company's update is not in service?
Again, staff had concerns when we received the actual update for actuals, and we did send the DR out. I received the responses, and also the company has explained how they came to the actual number for December that seemed to me higher than it should have been. I believe that would be a question for engineering division to see what is appropriate to include as far as reliability spend inside. The spend will be the accounting portion of it, but actually the reasoning behind including it would be the engineering division decision.
I understand, and thank you. And just to be clear, so as a member of the accounting staff for the Commission's technical staff, as you sit here, you're not aware of any plans to engage in any additional investigation if it turns out that the land that's described in the response to staff 44 turns out to be not in service?
Again, if it's not used and useful and not in service, meaning we will make this adjustment to remove it, because my understanding, and again, the engineering staff can confirm, my engineering is we believe that only what is used and useful should be moved to rate base. If it's not used and useful, so staff would not recommend moving it into the rate base.
Okay, thank you. Thank you, Ms. Bobrowski. Your Honor, I don't have any further questions. I would ask that OPC Exhibits 14 and 15 be moved into the evidentiary record.
No
Hearing-
objection.
No objection.
Hearing no objections, they are admitted. Thank you, Mr. Cleaver. Any redirect, Mr. Spivak?
No, Your Honor.
Thank you. Good afternoon, Ms. Bobrowski.
Good
Thank you for
afternoon.
your testimony. So I have a couple of questions. One is, I think, just to make sure we're correct here. On page 9 of your direct testimony, I think it's just a potentially a typo. You refer to BGE's lead lag study?
It is a typo, I
Right,
apologize.
okay. I was certain it was, but I just wanted to make sure.
I believe Potomac Edison had a DR about it, and I specified that it was a typo.
Okay, thanks. I wanted to ask you about, well, I'll talk a little bit about the legal fees. Do you, acknowledging that the commission in a Columbia Gas case thought $300 an hour was the appropriate amount, do you think that it might be appropriate to reflect reflect inflation in that number, for example? 5 years, it's, costs usually go up.
The commission can decide on that. Whether it's appropriate, staff would not object to it specifically. The amount would still be much lower than the actual amount.
Mhm.
Therefore, it can be a good way to. But again, as I was telling the PE Council, the per hour rate that was specified in Public Utility Law Judge's order is similar
Mhm.
to what is incurred right now.
Okay.
And $300 range was basically a 50-50 split proposed by staff because it benefits, may benefit ratepayers as
Mhm.
well as the shareholders. When we don't have any other study to rely on, we try to come up with a balance between the two interested parties.
Okay, thank you. With respect to the PE corporate financial expenses, which is on page 16 of your direct testimony,
Yes.
this is this the treasury, those kinds of expenses, corporate secretary, that sort of thing?
Potomac Edison lists that as stock administration cost, investor relations expenses,
Mhm.
and audit fees. It seems to me that it's more of a shareholders share that should cover these expenses. But
Well, but if PE were a standalone company, wouldn't they have to have an auditor and have to perform these functions anyway, itself?
if I can refer you to the DR that we received from Potomac Edison about it. Let me tell you which one is that. It should be attached to my direct testimony. States here, staff data request 6-25.
Ah, there it is, okay.
Those are, as PE explained, those are First Energy Corp costs that are basically allocated only for rate-making purposes. They are not otherwise allocated to PE.
Mhm.
And I can be corrected if that is not information, but that's what how I understood the data response that was provided with regards to this adjustment.
So when they respond corporate expenses, those are the corporate expenses you're removing?
Yes.
Okay.
On page 16 of my testimony, also, the connection of these expenses to benefiting the customer is unestablished.
Okay.
And the costs are not part of normal allocation of costs between the parent and affiliates.
Okay, thanks. Now, moving to the your discussion of the financial incentives. Am I correct that the total number that you're removing, of the total cost of your adjustment is SERP plus the financial part of the STIP and LTIP?
No, incentive compensation adjustment includes only removal of financial goals from long-term incentive and short-term incentive.
Okay.
And I calculated this adjustment based on DRs, like several DRs that's be provided, and they are also attached to my direct testimony.
Right, I saw those. There was I guess the short-term plan is 31% and the long-term plan is 67%.
That's correct.
So you removed those percentages from the amount.
Right. In DRs, in staff DR 827, they split the amounts between short-term and long-term, and I applied the percentages to each incentive pay separately to combine my total adjustment for,
Okay.
to remove the financial goals.
Thank you. That's helpful. That's all I had. Thank you very much. Commissioner Richard?
Yeah, I don't really think I have any questions. Well, maybe on your SIR rebuttal, there's a discussion on page 2 just about regarding the company's most recent update for December 2018 actual plan investments. And in that you say the staff is concerned with the actual amount of the spend for December 2018 being significantly higher than the amount the company originally projected. So is your only recommendation at this point there is just that the company strive to have better projections? Is there any other issues?
As I was explained by Potomac Edison, in December is a month when they try to put everything as much as they have through the year. I was explained that it was not specifically December spent, but all the updates that they have received through the year. But since it's the end of the year, they included it in this December last update.
Okay. And how significantly higher is the number? I was looking for an
It's actually doubled.
It doubled, okay.
That's why we had a lot of concern with that.
Okay. But the recommendation is the company should strive to do better in future forecasts is what staff would like to see.
Right. I was surprised that it was not included in the budget. And the majority of this expense was Commissioner's Herman data request. They issued bench data request about the software. It was approximately $500,000, which was, that was the reason for such an increase.
Great. Thank you very much.
Ms. Poboreski, thank you for being here. I only had one question for you, and the chairwoman already asked it on short-term and long-term investment compensation. So have a nice day. Thank you.
Thank you.
Thank you again for your testimony.
Of course.
Mr. Spivak, your next.
If I might just have just a minute to switch gears from Ms. Poboreski to Mr. Baker.
Sure.
There was a data request response, which I gather got answered by staff on the lunch break that included a question to that.
Yeah.
Who has that? Is that maybe?
Mike actually does. Do you have a copy of that response?
Could we take a second to look at it?
Yeah. Yeah, actually do that. Okay. Thank you. There we go. All right then, we're ready. Commission staff calls Benjamin Baker to the stand, please.
Swear and affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon, Mr. Baker.
Good afternoon, Mr. Spivak.
Do you have in front of you a document captioned in case 9490 entitled Direct Testimony of Benjamin Baker on behalf of the staff of the Public Service Commission of Maryland and dated November 20th, 2018?
Yes.
And does the document consist of 3 appendices and 35 pages of question and answer testimony?
Yes.
Did you prepare this document, or was it prepared under your direct supervision?
Yes.
Do you have any additions, deletions, or other corrections you would like to make at this time?
Yes.
Can you please tell us what they are? And give us
Page 14, lines 5. The number 520, 697 should be updated to 450, 455.
Page 14, line 7. Oh, okay.
Line 5.
450, 455.
Yes, sir.
Okay.
And pages 19, line 1. Delete the word as discussed, or delete the words as discussed later.
All right. And with those changes, if the questions were asked of you today as they are asked in this document, would your answers be the same?
Yes,
And do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Mr. Baker's direct testimony be marked as Staff Exhibit 17.
So marked.
Now, Mr. Baker, do you also have in front of you a document captioned in case 9490 and entitled Surrebuttal Testimony of Benjamin Baker on behalf of the staff of the Public Service Commission of Maryland and dated January 16th, 2019?
Yes, I do.
And does this document consist of 22 pages of question and answer testimony?
Yes.
And again, 3 appendices.
I believe there's 4. 1 second. There's a 4th appendice, Lloyd.
Okay.
Mr. Spivak.
Thank you. Did you prepare this document, or was it prepared under your direct supervision?
Yes, it was.
And if the questions were asked of you today, as they are asked in this document, would your answers be the same?
I would like to make some edits to this document.
Okay. Please tell us what those would be,
Yes.
and offer whatever explanation you need to offer.
Yes. Page 1 of my direct testimony.
It's direct or
Oh, sorry, sir, rebuttal. My bad. I would like to remove recommendations 1 and 2 and replace them with P should allocate buildings and structures based on my recommendations on pages 5, lines 1 to 4. And 2.
Hold on a moment. All right, and 2.
And 2, P should separate general plant costs based on my recommendations on page 12, lines 7 to 12.
And the buildings and structures was page 5, lines
1 to 4.
Okay.
page, that same correction needs to be applied to page 22 of my direct testimony, or my sir rebuttal testimony.
So that's to numbers 1 and 2, the recommendations, 1 and 2 and the conclusions?
Yes. Page 14 of my sir rebuttal, line 2. The word labor should be replaced with plant. And finally, I'm replacing tables 3, 4, and exhibits J, C, O, S, S, B, C, B, S, R-1, C, O, S, S.
Now, am I correct in recalling that the reason for replacement is that part of them got cut off in the original copies?
No, these are the updates that were filed on the 22nd of COS, BCB, SR-2, and the first page of General Intangible Analysis, BCB, SR-3. These tables and exhibits were all updated
On January 22nd?
Yes.
So they were included in the update?
Yes.
We'll enter that as a separate exhibit.
Okay. I would still like to remove these, though, because they're wrong at this time.
Okay.
Yeah. And finally, the remaining pages in BCB SR3, I'm providing an update to not an update, but some of those pages were cut off when they were printed, and so I'm providing the data tables such that they are not cut off anymore.
Okay. Again, I just handed out these tables. Which tables are they replacing again?
This is replacing 1, 2, 3, 1. This is replacing pages.
It looks like attachment A.
No, this is attachment. Right, this is staff 31-2 attachment A that I included.
Okay.
That should be about 12 pages.
Okay. All right then. And with those changes, do you adopt this document as part of your sworn testimony in this proceeding?
Yes, I do.
Your Honor, staff requests that Mr. Baker's rebuttal testimony be marked as Staff Exhibit 18.
So marked. Mr. Spivak, is this document you just handed us meant to be included as part of 18?
It is.
Placement pages?
Correct.
Okay. Is there any... Oh, go ahead.
Okay. And last but not least, Mr. Document, do you have in front of you, Mr. Baker, do you have in front of you a document that was filed on January 22nd of this year, the first page of which is headed Updated Sewer Rebuttal Tables?
Yes.
And the last page of which doesn't have a header, but is several columns of decimal numbers with a first column.
Yes, those would be the allocators used in the cost of service study.
And that goes down for about a third of the page on the last page, is
Yes.
that right? Did you prepare this document, or was it prepared under your direct supervision?
Yes, I did.
Do you have any additions, deletions, or other corrections to make at this time?
No, I do not.
Okay, and what was the reason for the preparation of this document?
The company filed updates to actuals on January 16th. The updates to these tables is to reflect this flow through and those updates made by witness Proveski. Additionally, I had discovered errors in where the joint cost of service study and the cost of service study in table 4 of my testimony were not using the same data. So this fixes that issue, that error as well. And it also fixes the alignment issues between those studies such that they now align.
Okay. And do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Mr. Baker's updated sewer rebuttal tables be marked as Staff Exhibit 19, please.
So marked.
And the witness is available for cross-examination.
Do you want to move these into evidence, Mr. Spivak?
I can wait. Actually, let's do that now then. Yes, staff will request that Staff Exhibits 17 through 19 be admitted into the evidentiary record.
No objection.
They are admitted.
Thank you, Your Honor. And with that, the witness is available for cross-examination.
I'm sorry.
Thank you, Your
Please
Honor.
proceed, Mr. Trout.
Good afternoon, Mr. Baker.
Good afternoon.
I have only two things to do with you, and hopefully they'll both be very quick. The first involves looking at one of the prior data request responses the staff provided. Your Honor, may I approach?
Yes.
Mr. Baker, I just handed you a one-page document that consists of a question labeled PE-3-1 and the response provided by staff to that question. Do you see that?
Yes, I do.
Your Honor, I'd ask that this be marked as applicant's Exhibit 26. Mr. Baker, did you prepare this response?
I did.
Is it true and accurate to the best of your knowledge and belief?
It is.
I move the admission of applicants 26.
No objection, Your Honor.
That's half my cross. Now, and I apologize in advance if the second half is not quite as efficient, but you'll understand why in a second. Mr. Baker, did you also respond to an additional data request from the company that was labeled Potomac Edison 7-1 to staff?
Yes, I did.
And in fact, although the response to that I don't think was due until the end of the day today, you shared with us just a few minutes ago the staff's response.
Yes, I did.
Okay, and I thank you for that. I appreciate it. You got on quicker than I think any of us anticipated, and it was very good of you and of staff to accommodate us by sharing that answer before you testified. So in that, and we don't, the reason this is going to be a little clunky is because we don't have copies of, Mr. Baker has a copy of the question and answer in the form of all the other questions and answers, but nobody else does in the room because it's only been circulated electronically up to this point. But I think we can get it verbally.
We'll try to get there.
Very, very, very quickly. All right, so the question, and you have the question and answer in front of you, right?
I do.
Okay, good. Great. So the question asks, referring to your rebuttal at page 5, you recommend a certain methodology for the recovery of costs relating to service centers. And the question asks, if the Commission were to adopt your methodology, would it be possible that Potomac Edison would not recover in either Maryland or West Virginia certain service center costs because this Commission, in adopting your methodology, would be using a different methodology than the one employed in West Virginia? That's the substance of the question, right?
Yes, it is.
And am I correct in understanding that your response is you haven't specifically investigated that, but that's possible?
It is. I can read the answer if you would like me to.
Why don't you read the answer? That would be great.
It is possible that some costs associated with service centers will not be recovered in the rate effective period by either West Virginia or Maryland rates if Mr. Baker's proposal is accepted. But Mr. Baker has not evaluated PE's cost recovery in West Virginia. Please refer to Table 1 of Mr. Baker's rebuttal testimony for the estimated impact to PE's proposed joint cost of service study if Mr. Baker's proposal is adopted.
Thank you. So what you're telling us in that last sentence is there is data. It's now in evidence because your testimony has now been admitted. And if we wanted to go and try to do that sort of calculation ourselves, that's where we would look for the data.
Right. You can back this out. Also, it has been provided to you electronically, so you can see how I calculated this as well.
Very good. Thank you. That's all I have, Your Honor.
Okay. Thank you very much, Mr. Trout. Mr. Cleaver?
Yes, thank you, Your Honor. Good afternoon, Mr. Baker.
Good afternoon.
Just a couple of questions for you. Just following up on what you were just talking to Mr. Trout about and the references that you made within your testimony based on the corrections you did with Mr. Spivak. If you could turn to page 5, lines 1 to 4.
Yes, sir.
And when you say I recommend service centers whose operation, I'm on your rebuttal testimony. I don't know if I said that.
Yes, page 5, lines 1 to 4.
Yes.
Yes, sir.
When you recommend that service centers whose operations impact both Maryland and West Virginia be allocated on the basis of plant, you're speaking about Cumberland and Williamsport, is that right?
Yes. So the numbers I included in here, or the line items that I included in here, were Williamsport, the Beverly Service Center that's located in West Virginia, the Cumberland Service Center, and also there was a storage center that is attached to Williamsport that I also included.
Okay, thank you. If I could turn your attention to page 8 of your rebuttal testimony.
Yes.
You discuss on page 8 your efforts to evaluate general and intangible plant to determine the cause of cost. Is that right?
Yes, I did.
Okay. And if you turn to page 9 and look at table 2, the results of your analysis are set forth there?
Yes, they are.
Okay. Now going back to page 8, line 1, question asks if you were able to determine what was the cost causation for general and intangible plant, and your answer is partially. Going back to table 2 on page 9, is the partial part looking down at these totals on the bottom row, is the partial part the 26% and the 54%, so 80%? Is that what you mean by partially?
Correct.
Okay. So the remaining 20% in the indistinct column is the part that you weren't able to determine cost causation for?
Correct.
Okay. And would you agree that 20% is not insignificant?
I do not disagree. That is not insignificant.
Okay, thank you. And you, again, going back and forth here, on page 8 at the bottom, you explain that some FERC accounts are driven primarily by plant, some by labor, and others you can't determine at this time. You say I was not able to determine the cost causation reason for many descriptions because either the names or description of the plant was too broad. What type of information would you need to determine cost causation for this 20% indistinct category of plant?
So this ranges across various categories. As you can see, FERC accounts 393 and 394, they had a large amount of money that I was not able to determine which line, or I was not able to judge which line items I believe should go to which accounts. So at this point, I had propounded data requests to the company asking to describe what is in these accounts, and there were a couple back and forths. And at the end of it, based off the descriptions, as you can see I'll just use FERC account 393 as an example. This is on page 10, lines 11 to 15. If it was clear to me that the items that were being stored in this location, based off of their descriptions, was based off of poles, I assume plant, but otherwise I was not able to tell you what was being stored there. So short of the company either describing to me what is at these various locations or me going and looking at them specifically, I couldn't tell you what is actually occurring with that plant item.
And if you turn to page 12 of your rebuttal testimony, at line 6, you're asked the question of what is your final proposal? And you explain here what that is. You take a moment to look at that.
Yes, I see it.
Yes. Is that proposal intended to address the 20% of plant that you've deemed indistinct?
Is this lines 10 to 12?
This is, yes, 10 to 12.
Then yes. So I determined that a grouping of the end result that I chose to pursue was if a FERC account that I believed to be obviously plant, I allocated that based on plant. If I believe the FERC account to be based off labor, I allocated it based on labor. And then finally, for the two FERC accounts, I believe it's 393 and 394. I'm not sure. At least those two plants. I'd have to check my numbers to make sure there were no others included in there. But I allocated based off a ratio of identified plant to identified labor. And that's how I then allocated that between the two. And I believe, yes.
Okay. And that method as set forth in lines 10 to 12 here on page 12, you would agree that there are assumptions built into that approach to dealing with those?
Yes, I would agree that my whole analysis is based off assumptions.
Thank you. And going back to your overall approach as described on pages 8 and 9 of your rebuttal testimony, this is one of the three general and intangible plant allocation methods that's described in the NARUC manual that Ms. Oblak and Dr. Pavlovic both talked about, correct?
Yes.
And it's the one that's described in the NARUC manual as the most complicated, correct?
I mean, I know this page is in Laura Black's rebuttal testimony, if you'd like me to look at that for a minute.
Do you have that with you on the
Yes,
stand?
I do.
I think it's Exhibit LMO 10.
Yes, I believe it is. Yes. Give me 1 second, please.
Sure.
Yes, I agree that there's a line in there that says this approach is more time consuming and presents additional allocation questions such as how to allocate the common facilities such as the general corporate computer space, the shareholder relations, office space, etc.
Thank you. And to complete the entire analysis that you think would be appropriate, how much more time do you think you would need from now?
I couldn't tell you. The company was very helpful in providing me data requests that were descriptive enough for me to even begin this analysis. This is based off of assumptions, this analysis, but I thought it would be a good way to help us shed light on on the most appropriate cost causation metrics of these FERC accounts. So what is causing these FERC accounts? And so this, as page 105 shows you, there are three different ways of doing this. So I decided to go in and try and determine if there was a way to classify these costs on a more specific basis once it was determined that we had two opposing arguments for this. And that is why I put forward the recommendation that I put forward, which I believe to be a valid analysis to determine how this is done based off of the company descriptions that have been provided up to this point. There could be refinement, and yes, it would take additional time to complete it, but I cannot provide an estimate in order to tell you what would need to be done, or in terms of what would need to be done to finish it.
Okay. Thank you, Mr. Baker. Your Honor, I don't have any further questions.
Thank you very much, Mr. Cleaver. Any redirect, Mr. Spivak?
Just a little bit. Mr. Baker, do you recall the conversation you had with Mr. Trout regarding the data requests that we don't have copies of yet?
Yes.
Okay, and what specifically was the concern that he expressed to you?
That PE would not be able to recover cost related to service centers out of their rates if the allocation method that I had proposed is incorporated.
And why was that?
Because the allocation, the method that I have proposed would remove some cost from the Maryland rate base.
Okay.
This gets into the issue of to me, this gets into jurisdictional issues. So we have West Virginia who has who says that we want to allocate these directly, it looks like. But here in Maryland, as I discussed in my SIR rebuttal testimony, if these, and as I discussed, these service centers have operations that are, the ones I identified at least, have operations that are benefiting both Maryland and West Virginia. And so to take some of these costs and move them out of the out of Maryland and into West Virginia might be more equitable to the Maryland ratepayers, since they would otherwise be footing the entire bill for these service centers.
Okay. Now, did I hear you say agree that it was a possibility that their concern could come to pass?
Yes, this could be possible but this all depends though on what costs are being currently recovered in West Virginia. Their last rate case was before this rate case, so the return on equity, the other costs associated with this, all are changing, and so they're not being run at the same time. So there's different costs already in this cost of service. Also, I do note in another data request to PE when I was asking them as to why they did this. Essentially my question to them was, you're changing your methodology from the previous time you were here in Maryland. Why? So this would be a new method in Maryland that they're putting forward here.
Now, all right. So you agreed it was a possibility that what they said could happen. Is it also what are the other possible outcomes?
I mean, it's possible they could go up or stay the same, but all I can say is that in Maryland, if my recommendation is taken, that the revenue requirement that the company has put forward, I believe, would go down if implemented.
Okay. All right. Thank you, Mr. Baker.
Thank you, Mr. Spivak. Good afternoon, Mr. Baker.
Good
Thank
afternoon.
you for your testimony. Okay, so have you done reviewed jurisdictional studies for Pepco or Delmarva?
Jurisdictional, I did try and find some. I'm not going to. I didn't find anything that was concrete. Pepco, I think I did see something that dealt with distribution costs going between the two jurisdictions.
Mm-hmm.
But I wouldn't say I was an expert after my review of those.
Okay, and you haven't testified in either of those?
No.
With respect to a jurisdictional study. So, in your testimony, generally speaking, there's a couple of places where you say this, this should be, we should be updating this, we should be reviewing this. I don't think it's the whole cost of service study, but there are sort of pieces that go into the cost of service study that you believe should be updated. Can you help me out to understand what it is you think needs to be updated?
Yes, there are actually 5 studies, and I discussed them in my direct testimony. One minute, I'm looking for the right page. So I discussed this across pages 21 to sorry, this one did go on for a little to 31, and also so the 5 studies are: there's a zero intercept study, there is a pole separation study. 1 minute. Or I should say a pole sample study is what it's called. There is a there was one that was used to create allocators for the customer accounts and services to allocate meters, or there's one to allocate customer accounts and services, and the other to allocate customer meters. And I'm sorry, I'm looking for the 5th one. Oh, and there was also another study from 1993 which separates primary and secondary costs from conduit and conductors in FERC accounts 366 and 367.
Right.
That's on page 21.
So in your experience in reviewing other rate cases, are these inputs usually updated by companies that are applying for revised rates?
I can't say specifically. I'm trying to. So as I discussed in my testimony, the 3 investor-owned utilities do not form the zero intercept study. And then the cooperatives, I would have to, I don't remember in my reading if they discussed if it was updated or not.
Mm-hmm.
So I can't say, but I do know for cost causation principles that that you want your the inputs to your test year to be most reflective of your test year. Oh, I'm sorry. You want the inputs to these studies to be most reflective of the test year for cost causation reasons to help ensure that there is no unfair allocation amongst the classes in terms of the cross subsidization that might already be present.
Right. And do you have an opinion about over a 25-year span, with a significant changes in a service territory that might impact some of these inputs into your studies?
Yes, I mean if the number of customers are increasing, if your amount of rate base has been changing, the type of rate base, if our reliability standards have been changing, those investments, then you should be. These seem to all be valid reasons to update a study. So I mean, there is a balance between what's the cost of updating the study versus the impacts to what it's going to do. But as I laid out in my testimony, I believe that these studies do have impacts on how we allocate costs. So even though they're not impacting the company's earnings, they are impacting which customers bear the burden of paying these costs when we allocate our cost in the rate-o-matic later. So I think every so often these should be updated, and I think 25 years is enough time to consider that these should have been updated at this point in time.
Okay. Thank you very much, Mr. Baker.
Thank you.
Commissioner Richard.
Good afternoon.
Good afternoon.
I don't know if you were here when I engaged and had a conversation, I guess, this morning with Mr. Pavlovic, but I asked a couple questions specifically, trying to compare and contrast what your recommendations are. So,
okay.
To that first on the regards to intangible and general plant, if I understand correctly, your recommendation really isn't complete yet. You're just proposing that.
No, my recommendation is complete.
Okay. But you say you need to have these additional studies, or you're just suggesting that in the future to refine your recommendation or to make it, I guess, more precise.
This
That's
recommend
necessary.
Right. This to in my testimony, I put forward an analysis that I'm using to base my recommendation on how I believe these costs should be allocated. That study could be improved upon, and that study and more time could be dedicated to it because yes, there were costs in there that I did not allocate because I did not separate between the two because I didn't know what to do with it. But I did put forth a proposal that essentially said if I believe that I was able to identify enough of the items in the plant in the account as plant, I would say let's allocate it to the based on plant labor, and then otherwise there's a bit of a split the difference, but the ratio of the labor that's been identified versus the plant that's been identified and allocate it that way otherwise.
Okay, but you have confidence in your I guess your judgments at this point,
Yes.
even though they could be improved upon with these studies and further information. So that's
Yes.
That's what I should take from your testimony.
Yes.
Okay. The other question I asked Mr. Pavlik was really about for the cost of service study. With the zero intercept study and without. So your position, if I understand correctly, is that for this rate case, we should use your the weighted approach.
Can you say? Sorry, can you repeat
I
the
said the
question?
way we should use the cost of service. I'm sorry, the zero intercept study, and weight it in that
Yes.
study. And just why do you think that's a better approach now than was suggested by Mr. Pavlovic, that we just discard it altogether?
So I believe that this approach is, I think, a fair compromise between the position that we've been put in here, where we have a zero intercept study that is 30 plus years out of date. That, as I do point out in my direct testimony, does, if you have it in or take it out, this will affect who's going to pick up what cost. But at the same time, this does one of the overall impacts of the cost of service study is pitting customers with more demand but less customers against the class with more customers, which is essentially the residential versus your industrial and commercial customers. And so if there are costs on the system that could be that are driven more by just the number of installs or the number of customers that are demanding them, then it would be inappropriate not to consider the fact that might be impacting those customers. And so that's why I recommended this split. I gave more weight, though, to the one without the zero intercept because it has more, without the zero intercept, you're removing a lot of the bad data itself.
Okay. Is there a point that a service territory, because I think you mentioned that our two other investor-owned utilities do not use the zero intercept method.
Right.
Okay. So should there be reason that one investor-owned utility continues to use that methodology and while the other two don't, or is there something about these service territories that may require that we consider?
I don't know if I can make that judgment at this time. I know that if you go through my testimony, I tried to do a survey of where we were at, and you effectively had BGE and DPL and Delmarva have filed against using them before, even though staff in those two cases was recommending one be provided or used, and then PEPCO I'm not aware of using one either. So it's mostly been the cooperatives that have propounded the use of a zero intercept study in the state, and the investor owns that have not.
Great. Well, thank you very much.
Good afternoon, Mr. Baker.
Good afternoon.
I wanted to delve into one of these studies that hails from 1986.
Yeah.
You might not have even been born back then.
I was not.
Sorry, I couldn't hear it. You got to have some, at least a little levity. That was meant as a compliment. So on page 22, you begin your discussion of what a pole sample study is, and in lines 3 and 4 you talk about the difference in ratios of poles dedicated to primary versus secondary versus lighting service. So lighting service or street lighting is intuitively obvious to me, but could you distinguish for me the difference between a primary service and a secondary service?
I'm not an expert in this, so
That's okay.
the primary service polls, and this would probably actually be a good question for engineering to verify this. But my understanding is that these would be larger service poles. As you go down the service system, you'll have less. The pole size probably is not going to be as
So a
large.
larger home or a larger commercial.
Right. So you usually see some of the industrial customers taking service. You'll see less as you go down. You'll see less customers on the service, and that's because they have smaller demands on the system. So they'll interconnect at lower voltages, but some customers can connect at the higher voltages, which would be at the primary level. So these poles would be supporting higher voltages.
Okay, fair enough. And tables 9 and 10 in that discussion, there are two components to this analysis. One deals with the number of customers, and one deals with the amount of demand of the various classes, right? So you discussed it a little bit. Number of customers and demand are two components.
Right.
Would you remind me what the various classes are? So we have residential coming across the top of table 9, and then commercial, and is that general? What is?
I believe that's Drew McAuliffe or Witness McAuliffe for the official names, but to me, I believe that the C and G and the CA, CSH are commercial classes. PP is industrial, street lighting. PH, I'm not sure. That could be industrial, but I'm not sure.
Okay, fair enough. I don't know if you heard my discussion with Witness O'Black about the changes. There was discussion presented by the company about the eastern part of their district and around the Frederick area having large residential growth, and then my discussion with Ms. O'Black about the large changes and the flight of industry and large commercials from Western Maryland over the last several decades. Did you hear that discussion? Do you recall?
This was Miss O'Black. I believe I heard some of it, but if you could refresh my memory.
I was noting that although there was discussion about the change in residential, that certainly there was a change in large commercial and industrials having left the area.
Right.
Generally. Would that have a big potential impact on something like this, the ratio of residential customers to commercial customers and the allocation that derives then from this?
I think it depends. So,
but you wouldn't know until you did the study, right?
Right. You would, yes, because you would need to know how many customers have left, and so you would have to essentially look at how the class has changed over time in terms of the number of customers, and I think more importantly, maybe the kind of demand that went with that customer. So if your industrial class went from 10 to 20 customers or 20 to 10 customers on the customer versus when you have your residential classes in the thousands, that's probably going to show up as noise, right? But if those 5 to 10 industrial customers, the demands they bring to the system or take from the system could be a lot larger compared to others. So so in terms of customer count, that might not change it as much, but if you look at, depending on what demand they bring, that could have a swing.
Okay. So your overall recommendation on these 5 studies is that they be done within 1 year of the next base rate case.
Right. And that is to align it as close to the test year as possible.
But considering the recent history of this investor-owned utility, hasn't been in for 25 years.
Mm-hmm.
Yeah. We might not get one for a while, but if you're suggesting that we need these studies in close proximity to the base rate case for most accuracy and the most appropriate cost allocation to the classes, wouldn't it be important that we not, if there are inaccuracies associated with a 1986 study or multiple 1986 studies or a 1993 study or a depreciation study that's very old, wouldn't it be important for us not to allow those inaccuracies to exist at the discretion of the company filing its next base rate case? In other words, they may not come in for another 10 years.
So essentially force it to be fixed now? Is that what you're asking?
We can't tell, generally, unless it's in the public interest, I suppose. We don't tell companies when to file rate cases, unless there's a compelling reason to.
Right. My recommendation isn't asking the company to come back in within a year with updated
Now,
studies.
I understand that, and I think that's the concern I'm trying to articulate. Is you recommend we need new studies, but you let it to the discretion of the company as to when we get those new studies, and I'm suggesting it could be 5, 10, 15 years down the road. Who knows when?
Right.
I doubt it. I suspect we've heard that the company will probably be more frequent now, but had you considered that in your recommendation? And do we need to do something? Do we need to consider doing something if inaccuracies are being introduced in this proceeding, in this case?
So I did not take that into consideration if it should impact our, in terms of asking the company to be back within a certain amount of time with the studies updated. The reason I had asked them to do it by the next one is because at that point we could fix it with the company's updated data. Now, in terms of going into the future, in terms of wanting to have them come in sooner rather than later, if you set rates with the studies now, I guess it comes into when they come back in the future. Are we discussing the idea of retroactively trying to pull money back? So it gets into there's going to still be an issue of if you use the studies now versus and then you let them stay in effect for a small amount of time versus a long amount of time. Either way, that you've already put rates into effect with these studies, that's already impacting the customer classes in terms of how you've allocated the revenue to them. So the question is, at that point, are we discussing any sort of retroactivity, which I don't know if that would be recommended. I don't know if I would recommend that.
I don't think you can do that, but
right.
And I'm not suggesting that. But what I am saying is, if there are classes carrying more burden, rate classes carrying more burden than they should be. They're not close to unity on a UROR, or if there are classes carrying less burden than they should be, the longer we let that condition exist, the less equity exists for those rate classes that are carrying more burden than they should, right? Wouldn't you agree with that?
Yes, that's a situation that all of our utilities in the state face. I don't think I've seen a cost of service study where there wasn't some form of, inequity amongst how the costs were being allocated. And so
they're never perfect.
They're never perfect.
One is nirvana across the board, but we rarely get there. But we strive to get close.
Right, we strive to get closer, and so some of our investor-owned utilities, we're seeing them very often. And so there's there's also that downside of we're seeing them all the time instead of saying go out and let your rates take effect. So it's I guess a chicken and the egg question at this point.
But this is a very unique situation from all the other utilities in the state because of the age of the studies and analysis that feed the cost of service study.
Yes, but these rates also, though, have there are other rates which were probably also out of unity. I'm not sure, but if they were out of unity, that's been in effect also for the last 25 years. And now that we're aware of it, we can ask them to redo it in the future.
Yeah, well, I appreciate that testimony because that speaks even more to the importance of getting updated studies done. Thank you.
Thank you.
Thank you very much, Mr. Baker, for
Thank
your
you.
testimony. I'd like to take a brief recess till 10:04, at which time we'll take staff's next witness.
That will be Mr. McCullough, Your Honor.
Okay. Thank you, Mr. Spivak.
oral arguments.
Okay, we're back on the record. Mr. Spivak.
Thank you, Your Honor. The Commission staff calls Drew M. McCullough to the stand, please.
Do you swear and affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Good afternoon, Mr. McCullough.
Good afternoon.
Do you have in front of you a document captioned in case 9490 entitled Direct Testimony and Exhibits of Drew M. McCullough on behalf of the staff of the Public Service Commission of Maryland and dated November 20th, 2018?
I do.
Does the document consist of 39 pages and 18 exhibits?
Check. Yes, it does.
And did you prepare the document, or was it prepared under your direct supervision?
I prepared the document.
And do you have any additions, deletions, or other corrections you would like to make at this time?
No, I do not.
And if the questions were asked of you today as they are asked in this document, would your answers be the same?
Yes, they would.
Do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Mr. McCullough's direct testimony be marked as Staff Exhibit 20, please.
So marked.
Mr. McCullough, do you also have in front of you a document captioned in Case 9490 entitled Sir Rebuttal Testimony and Exhibits of Drew M. McCullough on behalf of the staff of the Public Service Commission of Maryland and dated January 16th, 2019?
I do.
Does this document consist of 7 pages of question and answer testimony and 17 exhibits?
Yes, it does.
Did you prepare this document, or was it prepared under your direct supervision?
I prepared this document.
Okay. And do you have any additions, deletions, or other corrections you would like to make at this time?
I do not.
If the questions were asked of you today as they are asked in this document, would your answers be the same?
Yes, they would.
Do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Mr. McCullough's Sir Rebuttal testimony be marked as Staff Exhibit 21, please.
So marked.
And finally, Mr. McCullough, do you have in front of you a set of exhibits? The first one entitled Exhibit DMM3 Revised to Staff UROR 2-Step?
Yes.
And the last page of which is Exhibit DMM17 Revised with 2 in parentheses?
Yes.
Okay. Did you prepare this document, or was it prepared under your direct supervision?
I prepared this document.
And can you tell us quickly what the document is?
Yes, it's just a final update to my rate design exhibits. As being the rate design witness, you're downstream from all the other additions and subtractions that may happen with our accounting division or the cost of service study. So any changes they made had to be updated with my exhibits, and that's what this update is doing, updating every rate design for the new revenue requirement and rate base.
Okay, thank you. Your Honor, staff requests that Mr. McCullough's updated exhibits be marked as Staff Exhibit 22, please.
So marked.
Staff moves exhibits that exhibits 20, 21, and 22 be admitted to the evidentiary record, please.
No objection.
Hearing no objections, they're admitted.
Thank you, Your Honor. And the witness is available for cross-examination.
Okay. Mr. Kern?
Good afternoon, Mr. McCullough.
Good afternoon.
Nice to meet you. My name is Max Curran. I represent Potomac Edison company today. I'd like to start out, if I could, taking a look at your January 16th Sir Rebuttal testimony.
Okay.
And I only have a few questions for you this afternoon, but could you take a look at page 3? There's a Q&A there about reporting on the distribution bill increase or the total bill increase. You'd agree, you've had a chance to review Potomac Edison's application in this matter.
Yes.
And as a part of that application, they articulated both in the application and in Mr. Valdez's testimony that there would be a total impact of around 6% on the bill that would encompass the T&D and supply portions for the regular residential customer.
Subject to check, yeah, I believe it was 6% with the revenue requirement that PE is requesting.
Right, and here on page 3, you're talking about reporting on solely the distribution portion of that bill.
Correct.
Right, and you recall in Mr. Valdez's testimony and in the application, we indicated that if the commission were to grant the entire request of what the company is seeking here, there would be about a 26% increase on that portion of the bill, and that's what you're talking about
The distribution portion?
Correct.
Yes.
The distribution
Yeah.
portion, and that's what you're talking about here.
Yes.
Right. Well, I'm interested in the sentence here that you have starting at line 7. It says to report on the total bill may be misleading to customers considering that they may not have SOS service. Do you see that line?
Yes, I do.
Would you agree with me that after a base rate proceeding such as this one, the commission and its orders typically do report on what is the impact of their decision on the total bill?
Yes, in the commission order, they usually have a sentence that specifies the increase in total bill.
Right. So that wouldn't be misleading. That's giving, as a result of the proceedings, letting the customers know what the total impact would be.
Well, I would just say that the commission notes all the bill increases in the order. They do note,
Correct.
for example, customer charge increases as well. So the fact that they stipulate all the increases, I think, mitigates that misleading aspect.
And that's a natural part of this process and ultimately the commission's orders in the case.
I would say the commission still focuses on the distribution portion of the increase when they're approving their rate. They may also include the total bill just to give a general idea of the increase on the total bill, but I think their determination is based on the distribution portion, not the total bill.
Right. But it's fair to say when a citizen reviews the commission's order, pretty much right on the first few pages, the commission will communicate what the total bill impact is.
I can't say for sure which bill impact they normally put first.
Okay, thank you. Well, let me turn your attention to your discussion about the residential customer charge in this case. So you're the rate design witness for staff.
Yes.
You realize that Potomac Edison has the current customer charge is $5.
Yes.
And that was set back in 1994. There's a lot of discussion in this case about the last rate case.
Yeah, my understanding it was set in the last rate case, yeah.
And it's your understanding that charge has not changed at any time in the last 25 years.
Yes, that's my understanding.
So when the commission went through restructuring and unbundling the portions of distribution, transmission, and generation, that charge stayed at $5.
Correct. That's my understanding.
And you've heard questions from the commissioners about changes in the service territory over the last 25 years of businesses coming and going and growth, etc. That $5 charge has remained at that.
I believe so, yes.
And as part of your duties here at the commission, do you have an opportunity to look at the customer charges that are being incurred by the other states' IOUs on their bills?
Yes.
Right. And is it fair to say that Potomac Edison's customer charge is the lowest of any of the state's IOUs?
Of the IOUs, their customer charge is the lowest, but I would note that the revenue that PE collects from their customer charge is actually higher than some of the other IOUs. For example, BGE collects 19% of the revenue from the residential class through the customer charge, while PE currently collects 20%.
Well, actually, that's a good segue here. You agree that most of the, well, I'm going to ask you this if you agree, that most of the costs of the distribution systems don't vary with customer usage.
I can't say that. PE hasn't provided any study to say that. I haven't conducted any study. It's hard for me to say that no costs would be changed by customer usage.
Well, actually, this is my fault. I thought you said that customer service, billing, and meter reading, those sort of meters are fixed costs of the system that don't vary with usage. Is that not your testimony?
Usually, customer charges, companies try to encompass meters, services, things of that nature. Yeah, meters for specifically, the cost of meters wouldn't change with. That's more of a customer count.
And as a part of rate design, is it either a commission policy to try to recover more of your fixed costs through a fixed charge?
I guess I'm not sure what you mean by more, but yes, the customer charge is there to collect some fixed costs, yes. I wouldn't say all of the fixed costs.
And as a part of the rate cases that the commission has seen over the last few years that you've been involved with, have there been for the other IUs increases in the customer charge to try to recover more of the fixed cost of the system in that charge?
Sorry. There have been increases in customer charges, varying multiple levels. I think Pepco in their most recent case got about a 2% increase, 2.9, something like that. Something to check.
Thank you. Would you agree with me that even if Potomac Edison were to get everything that they have sought here for the increase in the customer charge, that would still be the lowest customer charge of any of those?
With their increase to 770, I subject to check. I think Pepco is 780. I know BGE is 790. So subject to check of the IOUs.
Right.
Yes, it would still be the lowest.
And how about of the state's cooperatives, Chop Tank and Smecco?
The cooperatives, off the top of my head, I believe Chop Tank is $11.75, and Smecco I think is somewhere in the $9, subject to check. I know some of the municipalities are lower than even PE's current rate of $5.
Actually, you're pretty good here. Chop Tank is $11.75, and Smecco is $9.50, so you're very close. And currently, those utilities, non-residential customers, they all have a customer charge.
I believe, yes, all of the classes, but again, subject to check. Off the top of my head, I'm not sure. All of the commercial classes, yes.
Right. And PE, Potomac Edison, does not have a non-residential charge to that.
No, not as of this time.
Right. And even if we, the proposal in this case is by the company is for a $12 customer charge for that class.
Correct.
Would that still be the lowest non-residential customer class charge?
I can't say for sure off the top of my head.
Subject to check, would you accept that?
I really can't say at this time.
That's fair. I should have had my facts ready for you. So, Your Honor, that's all we have for Mr. McAuliffe.
Thank you, Mr. Curran. Mr. Cleaver?
OPC has no questions of the witness. Thank you.
Thank you, Mr. Cleaver. Any redirect, Mr. Spivak?
Maybe a little. You just talked about the customer charge. Do you recall that Mr. Curran brought up the level of the customer charge, of PE's customer charge, as compared to the next lowest utilities?
No.
The level they're asking for as compared to the next lowest utility.
By lowest, do you mean Pepco by the next IOU utility?
Yes.
I didn't hear that, but I believe Pepco is 780, so PE would be 10 cents below if they get this.
Okay. How much did PE ask for originally?
$2.50. They wanted to go to $7.50 from $5.
And they since changed that to $7.70?
Correct.
Okay. And how does that relate to the next utilities charge?
It's only 10 cents below Pepco's current.
Okay, thank you, Mr. McAuliffe. That's all I have.
Thank you, Mr. Spivak. Mr. McAuliffe, if you could turn to your direct testimony on page 17.
Okay. Yes.
You list 4 issues with changes to the retail tariff, and I know that Mr. Valdez, and we've had some discussion about the postage, the due date question, but the three that are listed on page 17.
Yes.
Have you changed your position with any of these? Has Mr. Valdez addressed them to your satisfaction, or not
yes.
necessarily?
Sorry for interrupting. Yes, he has addressed those in his rebuttal testimony, and I was okay with the explanation. Really, here I was saying I felt that there was enough discussion of the changes in the tariff, and we just wanted to complete the record and have a little more.
Okay, so you're comfortable with these three?
Yes.
Then? Okay. That's all I had. Thank you very much. Commissioner Richard?
Good afternoon. Just again on the customer charge. So your recommendation is basically it's 5, and I lost it on my screen here, but it's about a 13.62% increase.
Right.
And just so I understand, it was a 13.2% increase recommendation just to keep PE at 20%?
Mm-hmm.
Okay. So
yes. Yes.
So that was the rationale.
Yes, with my actually with the updated, I believe now it's 565 and it's 12.9%. But yes, it was to just keep the ratio of revenue collected from the customer charge the same, which was 2.25, and with the way it worked out, it's actually it's not 2.55. Excuse me, 20.25% originally with PE. Now with mine, it's actually 20.55%. But yes, it was just to tie it to that same ratio.
Right, and then the discussion, it was noted that in the past rate cases, generally this commission has gone up 2 to 5%.
Correct.
So, did you consider that alongside the 13%, or now I guess it's 12%? I'm just curious.
Yes,
the rationale with going with the higher number rather than what I guess from the last several rate cases. The percentage increase we've.
Yes, we've definitely. Customer charge increases have definitely been lower than 12% usually in the last few cases. I think there was just some, also to keep that ratio the same, as I said, BGE is around 19%, so if we, say, only gave PE a 2% increase, in their customer charge, that number would drop pretty substantially, I would think. I don't have the number off the top of my head. But also, I guess we did take some consideration that has been 25 years. We're also trying to be gradual at the same time, not increase the rate too much, but, try to be fair and, when PEPCO comes in a lot more frequently, a 2% increase is a big difference.
Great. Well, appreciate your answers. Thank you.
Mr. McAuliffe, if you look on page 2 of your direct, line 11, it's your conclusion number 6, and you say, it caught my eye, PE's EDIS rate should only be charged on a kilowatt hour basis. Then I went back into the body of your testimony and read a little bit more about it, and then I go to your DMM 18, exhibit DMM 18. So if you could turn there.
Yep. Okay, I'm there.
First of all, are we talking about the little box down in the right-hand corner? With
Correct.
That? Okay. So I'm still hot on the trail here. Would you mind reviewing what the various rate classes are for me, what the letters stand for? So R's residential.
Yes, R's residential, the G and C are general commercial. If I one second. Get the exact name from PE's tariff. The G, C, CA, and CSH are all general commercial tariffs.
What's the difference between C, CA, and CSH? Is one small, one medium, one large, or what?
So the G, the C was the original commercial tariff. That has been closed since 1991. Okay. So G is replacing that. The C and the CH have both been closed since 1973. The CSH was a school heating, school and churches specifically. Okay. The CA, one second, if I can remember correctly, it's now they call it General Service All Electric. But again, that's been closed since 1973. So they had electric heat instead of natural gas and things of that nature. So they're all generally the same type of class.
PH?
The PH and PP are industrial classes. Again, the PH stands for Power Service, and and that's for 50 kilowatts or greater. And the PH is again Power Service, but that's for 500, I think. Oh, sorry. The PH was 50. The PP is 500 or 5,000.
Okay, so it'd be large industrial.
Yes.
Okay.
5,000.
Very good. Thank you for reviewing that for me. It's hard for me to keep these straight because they're all a little bit different in each by each utility. So my concept of a surcharge is that it's fixed. For instance, the customer charge. Residential, it's fixed, right? And that's part of the argument against it. It's counterintuitive to state policy because we're trying to get people to conserve their usage.
Right.
When you have high fixed charges, there's no incentive for that portion of the bill.
Right.
Anyway, explain to me the EDIS surcharge for residential. Why isn't it a fixed surcharge? Why is it a demand surcharge?
Well, I would just say, so for when BGE had the similar, theirs wasn't called EDIS, it's escaping me off the top of my head, but they had the similar surcharge. Theirs was based off a kilowatt hour basis. I guess because these are reliability improvements, it's hard to say just, because you're on the system, you have to pay the same amount. So you get more value.
There's a nexus to the impact on the system and the reliability of the system based on the demand placed on the system.
Sure.
Arguably.
Yeah. If a customer uses 1,000 kilowatt hours, obviously the system's more valuable to them if there's a loss in service than somebody who uses 100 kilowatt hours.
Okay. Thank you. That's helpful for me to understand your recommendation there. So I appreciate it. I have no other questions for you. Thanks.
Mr. McAuliffe, thank you very much for your testimony.
Thank you.
I think with that, we have Mr. Lowe and Mr. Vanderheyden remaining for staff. Is that correct?
That's correct, Your Honor.
And tomorrow we also have Mr. Spanos and Mr. Guerin, right? I think with that we will adjourn or recess for the day. Were we planning? I believe we're planning to take Mr. Spanos and Mr. Guerin first, and then take the staff after that. So that's how we'll plan to proceed tomorrow. And then on Monday we have Mr. Efron and Mr. Lanzalata, and we can fill in Mr. Lowe or Mr. Vanderheyden if we don't get there tomorrow. Okay?
All right.
All right,
Thank you,
we
Your Honor.
will be in recess then.
Thank you.